My name is Chuck Iovan. I'll be presiding over this evening's joint hearings between the City Council Ordinance Committee and the Planning Board, August 16th, 2022. I'd like to start with, for those in attendance, under the provisions of the open meeting law, attendees are informed that this meeting is being recorded by Urban Media Arts, formerly MATV. I have not been notified that any other recording or audio recording of this meeting will occur. The next thing we're going to do is we'll do the planning board roll call, and then we'll pass it over to the council to do theirs. So if we could start with Risa.
Risa Gray, Planning Board.
Planning Board.
Diane Shuha, Planning Board.
Ken Antonucci, Planning Board.
Chuck Iovan, Planning Board.
Michelle Romero, City Planner.
Eric McCush, Planning Board.
Ronnie Raj Verma, Planning Board.
Eric Henry, Planning Board.
Henry Susi, Planning Board.
Let me activate the councilors.
Peg Crow, City Councilor, Ward 1.
Carrie McDonald, City Councilor at Large.
Amanda Lenahan, City Councilor, Ward 3.
Thank you very much. So the first thing we're going to do is, Michelle, can you give us an update on Council Paper 315, please?
Yes, regarding City Council Paper 315 of 2022, that paper is not properly before the Planning Board for public hearing tonight. We need to give notice in accordance with the state statute and local ordinance. We will do that and schedule the hearing for another date. So there's no action that you need to take.
Okay, so Council Paper 315 will not be heard tonight and will be rescheduled for another meeting. We'll have to have another joint hearing with the Ordinance Committee. Ken, could you please read the papers, the
Notice of hearing.
notice of hearings for papers 286, 316, 317, 318, and 319, please? Yes. Oh.
The Malden Planning Board and the Malden City Council Ordinance Committee will jointly hold a public hearing in the Herbert L. Jackson Council Chamber, Malden City Hall, 215 Pleasant Street, Malden, Mass. At 7 p.m. on Tuesday, August 16th, 2022, in accordance with Title 12, Chapter 32, Section 050 of the Code of the City of Malden, regarding petitions for zoning amendments as proposed in City Council Papers 286 of 2022, 316 of 2022, 317, 2022, 318, 2022, and 319 of 2022, to further amend the following sections of Title 12, Chapter 12 of the Code of the City of Malden as follows. To amend the use regulation, to amend the use regulations for marijuana establishments as follows. To change the special permit granting authority, sections 12.12.010A, 12.12.190, 12.12.190B, 12.12.190G, 12.12.190G4, 12.12.190H, and 12.28.010E. That's CCP 286 of 2022. C, to delete the principal use requirement, section 12.12.190E, City Council Paper 316 of 2022. D, to amend the required condition security plans, section 12.12.190H2, City Council Paper 317, 2022. E, to amend the required condition regarding issuance of building permit and occupancy permit, section 12.12.190H9, City Council Paper 318 of 2022. 2, for use of new and existing buildings for the following uses allowed by special permit, to amend the use regulations to clarify and update language to reflect current protocol and administration and render consistent with current interpretation regarding relief required for noncompliance with dimensional controls and parking requirements. City Council Paper 319 of 2022. A, residential uses except for all structures more than 6 stories, sections 12.12.010A1 and 12.12.010A2. B, institutional, business, industrial, and other uses, sections 12.12.010B1 and 12.12.010B2. C, property with a preferably preserved building, sections 12.12.010C1 and 12.12.010C2. D, fast food service restaurants, sections 12.12.060A and 12.12.060B. E, restaurants, sections 12.12.070A and 12.12.070B. E, drive-throughs, sections 12.12.150A and 12.12.150B. G, gasoline filling stations, sections 12.12.160A and 12.12.160B.
Thank you very much, Ken. Michelle, can you give us an update on Council Paper 286/2022?
Yes, we received an email today that reads, "Good afternoon, Michelle and Chairman Iovan. Due to my wife not feeling well this afternoon, I will be in City Hall for another meeting. I have to leave early to drive my son to soccer practice. Unfortunately, this means that I'm no longer able to attend the planning board meeting. I respectfully request that paper 286 of 2022 be tabled till next month. I have spoken to the co-sponsor, Councilor Sika. She has no concerns with the paper being tabled. Please let me know if you have any questions," and he leaves his number where he can be reached, and he will be in City Hall until 6:30 this evening. And that's signed Craig Spatafora, Councilor at Large. He and Councilor Sika are sponsors of paper 286 of 2022.
Thank you very much, Michelle. So the sponsors of the paper are unable to attend this evening and have requested a tabling. Since we'll be hearing paper 315 at our next hearing, we can add this to it. Is there a motion to allow the tabling of Council Paper 286/2022? Ken Antonucci.
Yep. Mr. Chairman, I'd like to make a motion to table Council Paper 286 of 2022.
And is there a second? Hold on a second. Eric, can you ping in again? I missed you. There we go. Eric Henry, please.
I second that motion, Chair.
Thank you very much. Motion's been made by Ken Antonucci and seconded by Eric Henry.
To table the public hearing on paper 286 of 2022.
Yes.
Ken Antonucci?
Yes.
Diane Shuha?
Yes.
Tawadich Gebrselassie?
Yes.
Risa Gray?
Yes.
Eric Henry?
Yes.
Eric McCush?
Yes.
Henry Susi? Yes. Ronnie Verma?
Yes.
Charles Iovan?
Yes. So that paper has been tabled until the next hearing that we also hear paper 315. You all set, Michelle?
Yeah.
Okay, so the next paper that's on the agenda is the combination of papers 316, 17, 18, and 19. Councilor Linehan is the sponsor. Councilor Linehan, would you care to take us through your paper?
Yes, thank you, Mr. Chair. Thank you as well to the other members of the Planning Board and my colleagues on the City Council, especially those on the Ordinance Committee, which I vice chair alongside my colleague Peg Crow, who's our chair. The package of legislation before you represents a part of nearly 8 months of work that we've been working on to create hopefully a more equitable, streamlined, and easier to understand set of cannabis regulations. We've been working in partnership with the mayor's office, and there's been many, many hours of research, as well as analysis and recommendations from our legal team, our city planner, building commissioner, and our chief strategy officer, Ron Hogan, who I particularly want to thank just because of the many hours that we've spent sort of tracking state-level legislation that's impacted what we're trying to do here. So our goals were really twofold in sending this package to you. Number one, we've been looking to anticipate and prepare for a set of updates to cannabis permitting that we knew would be coming down from the state, especially related to equity applicants. But secondly, we're really looking to address hiccups in the process and discrepancies that have emerged as we've undergone the due process to approve applicants from the time that we legalized cannabis to date. So these proposals before you are really seeking to reduce redundancies and discrepancies between our local regulations and state regulations with the goal of making the entire process simpler. We're hoping to bring our regulations into line with one another and to really tidy up some wording in a couple of instances so that we're consistent across the zoning code. And then, of course, we want to make sure that we're maximizing our revenue and our commercial taxes for the quantity of cannabis businesses that we are required to host. So I do anticipate that we will have, in addition to those that are tabled tonight, we will have a second and potentially third tranche of proposals coming later this fall for us to review. We do want to make sure that we're reflecting those state-level changes that we've been watching. Those did pass, and they do necessitate some updates to our licensing fee structure. But tonight, the key proposal here is really to eliminate that primary use restriction, which is something that Malden and only one other community actually have in the entire state. This, I believe, would open up more flexible property types, such as strip malls, and importantly, it would lower the barriers and the cost of entry to doing business in Malden for cannabis businesses. You know, we're a working class community, and I think that this would not only help us to make sure that we reflect that in the businesses that are able to come here, but it would also prevent a recurrence of what I see as a pretty embarrassing scenario that we as a council found ourselves in earlier this spring when we approved a cannabis business in our downtown commercial district where almost 40% of the building had to be left empty, completely vacant and unusable, really only due to this primary use rule that, again, I feel is wildly out of step with the rest of the state. And that's just not where we want to be. We want to be a leader as a community. Importantly, I want to just note that these proposals will not eliminate or in any way alter the buffer zones at this time. They will not supersede any state regulations that currently bar cannabis from co-locating near schools. I understand that our local regulations go further than that, but this is not undoing or going further than what the state already imposes on us. It's not allowing new categories of retailer. If we want to take that up, that would be done separately if we wish to in the future. And it importantly also won't change the zones where cannabis is currently allowed now, and it won't change those accessory use regulations. So a strip mall is really the best example that I can give of what it would open up. There's very few parcels that actually fit that category, so while I do believe it would be a significant change, it's not, you know, it's not opening up hundreds and hundreds of more parcels. It's really a very restrictive thing that I think would still make a meaningful step in helping us to broaden our cannabis regulations. So I'll stop there because I think we may have some questions, and I'd look to our building commissioner if we want to do a deeper dive with any questions that I may not be able to answer, particularly around the wording and why we're suggesting specific changes to, you know, like the security plans and the occupancy permit and why that's a sensible thing for us to do. But as the sponsor, I think what I'm primarily interested in tonight is having a discussion about that primary use restriction because I think it has the potential to be the most impactful change that we could make at this point. Thank you.
Thank you, Councilor. And just so folks understand what's going to happen this evening, we're going to discuss all four papers, and we will take a separate vote on each one when the planning board addresses it. And then when people come up in favor or in opposition, they will be able to speak to any one or all four of the papers that we have before us this evening, 316s, 317, 318, or 319. And when you do come up, please make sure you sign in and lead off with your name and address for the record. Thank you very much. I also remind all planning board members to make sure that they speak into the microphone so that the recordings are able to pick up what we're saying, and the councilors also. Thank you. Michelle?
Yes, one just procedural issue. If you could also, when you sign in, print your name and address. Don't scribble a signature. We use those to document who attended the meeting and what comments we received. And if we can't read your name and address, we can't do that. So if you could please try to print neatly and so that it's clear the spelling of it. Thank you.
Thank you, Michelle. Okay, so the first paper. Counselor, do you want to talk through the first paper, or what? How do you want to handle this with your paper? I know you gave a nice overview there, but how do you want to handle paper 316? Do you want to describe what it is, and then? Oh, I'm sorry. Thank you.
Sure. So I think probably with the bulk of what I just said does go into describing this more than anything else. If it's your desire to take this up now, I'm fine to do that first. And
Well, it's the first one on the
Yeah,
agenda.
that's fine. I think that sounds
We've got 4
fine.
papers to review, so if you could go through this one. I know you had started to address it, but.
Sure. So again, the principal use requirement is, in my view, a restrictive aspect of our local ordinance right now that really makes it hard for, not only for otherwise reasonable parcels to be considered, but in the case of the most recently approved, I think it's Trinity, am I getting that right? The one that we approved just a couple of months ago. So, you know, that for me was really the moment where I realized that the principal use, I think, is holding us back. We can't realize the property tax revenue. The applicants can't use, in some cases, a full building because there's a part of it that's been subdivided that they can't utilize for cannabis as an accessory use. So what the goal would be is to open up, again, a small number of additional parcels that right now, you know, going back to that strip mall example, as long as the marijuana use is not accessory to another use, which is already covered in our ordinances, this would allow sort of equivalent uses, and Nelson, please interrupt me if I'm using the wrong terminology there, but this would allow kind of adjacent uses to exist, whereas right now, if somebody doesn't own the entire strip mall, cannabis can't go there. If the person that's trying to open up a cannabis establishment in one part of a 6-row strip mall, they need to own the whole thing in order to have any part of it be cannabis. So I think it's unnecessarily restrictive. We could adjust this and open up a select few more parcels, again, reducing barriers to entry for people trying to come into the industry, those smaller parcels that could do a reasonable business here. I think it hurts our ability to collect revenue on the cannabis itself. And then, you know, in the case of Trinity, we have a building right in our downtown that half of it's vacant. We have no power to do anything with it, cannabis or not, and that affects our tax revenue. So for those reasons, I think this is a sensible proposal that would have minimal impacts, certainly no impacts on neighborhoods, as it wouldn't be expanding where cannabis is allowed. It would be used in the exact same zoning areas that it's allowed now, but it would allow a different type of building, essentially.
Okay, thank you. Does anyone have any questions, or do the other councilors have any comments they want to make, or do you want to wait to hear? Okay. Does anyone have any comments? Eric McCush.
Question, not a comment, but thank you, Mr. Chair. 2 questions. One, when this was originally set up, weren't the regulations intended to be restrictive?
Oh, I'm sorry.
You know, I wasn't here when they were written, and I understand that a lot of work did go into that. I think it's reasonable to start with a lot of restrictions, but I think what we've learned is that we're holding ourselves back now. We have parcels that we can't fully utilize that I think it only harms us. I mean, we're lucky that we got an applicant for that building that could make it work, but I think, you know, you benefit from doing better when you've been through the process and you learn what's working and what's not working. And I'm so sorry, it's so awkward to not be able to actually face you while I'm talking.
No, don't worry
I'm turning
about
as
it.
much as I can.
You also could,
Seriously, Councilor, unfortunately, we don't have enough space up here.
I understand.
So we will take no offense to you speaking to the audience and addressing them. We won't take
Understood.
that
or
as,
speaking from the podium is the other option. As the presenter, they can they can address the board
They
as
can
the
do-
petitioner.
You can do that if you would
Right.
prefer to speak from the podium, but we are more than happy to have you sit where you are now and speak to the audience.
Okay, yeah, I think I'll stay here for now. I don't want to belabor the point, but I think, you know, in all due respect to the ordinance that we originally drafted, I think you learn what works as you get into it, and we found that there are just some things that could probably work a little bit better. So I don't think that this really meaningfully, you know, honestly, if it were up to me, I think I'd make it actually a little less restrictive, but that's not the will of our committee or our council at this time. So I think this is a really middle-of-the-road proposal that can, again, open up more parcels that are less cost-prohibitive, and in locations where we would have otherwise approved cannabis anyways, if not for the literal structure of those buildings. So again, it won't make it closer to, you know, schools, daycares, or anything else that we've written into our ordinance. It will just make, in an urban setting, what would otherwise be a very costly and, in my opinion, wasteful way of using a building less wasteful and more productive for our tax base.
Thank you. And just a follow-up question. We're maxed out on the cannabis permits that can be issued at this time, correct?
I think we have a minimum, not a maximum. Is that correct?
We have a maximum of 5.
Oh, I thought it was three.
License.
I misunderstood. I apologize.
Yes.
So I actually don't know what the status of the ones that are making their way through the process right now, but we have only permitted 3.
Okay, I thought 3 was the max, but apparently it's 5. Okay, thank you.
It's 5. Sorry, I misunderstood your question.
Okay,
I'm all
thank you.
set, thank you.
Thank you. Eric Henry.
Thank you, Mr. Chair, and thank you as well, Councilor Linehan, for presenting this paper to us. I was just wondering, do you have any idea how much of a housing stock or potential tax revenue base opening this up, as the rest of the state has, will potentially bring to us?
I think it's tricky because there are different layers that you have to look at, and I'm again looking at Nelson because we've had this discussion. Is there a way to quantify it? It's actually harder than than you think it should be. I think it's reasonable to expect that if we expanded something, we'd see, you know, certainly look at the Trinity example. That's a building that is, there's no question about it, is underutilized, and there's no path forward for that building to be utilized better. But you know, without being able to say this is how many parcels it would affect, which unfortunately we're not able to do, it's hard to say then extrapolate what that tax revenue would be, but you know, it would be higher than 0%, which is what we could realize now.
Thank you. Yes, sir.
Oh, God, yeah, sorry. I don't know.
Are you all set, Eric Henry?
No, sir. I thought the council was.
Can I respond to
Yeah.
this question?
I didn't know Eric had asked you a question. Okay, go ahead.
I didn't, but he's the counselor.
I just wanted to note that, you know, Malden has more types of restrictions on our cannabis business than any of the other peer communities that we looked at. So any of the individual types of restrictions that we have around buffer zones and, of course, you know, zones of where businesses can be located, these other types of use regulations, other cities do have them, but we asked our staff to go and chart out a couple of peer communities and see what they have on their books. And what we saw is that Malden has all of the different types of restrictions. And so one of the impacts of that is that it has made the process, I think, harder to access especially for social equity applicants, which is a policy goal that the state cares very much about and one that I and my colleagues care about on the council. But the other thing is that it makes it very difficult to model from a GIS perspective what the impacts of all these interacting things are. So we just can't, I mean, we asked, and our colleagues at the city were very clear, there's no way to generate a GIS map that takes into account the buffer zones and the principal use regulations and this, that, and all of the different pieces together, because they interact in so many unpredictable ways. So I do think a lot of what we're trying to do, and what Councilor Linehan has helped us put forward in collaboration with our city staff, is just try to rationalize all that. We now have the benefit of a few years of experience, not only in Malden, but in other communities permitting these, and we can see what has teeth and has impact. And so I think the intent of this, the principal use change was the strip mall example. And our understanding is that the way that the language that we sent to you to review would be interpreted is that it still has to be a principal use, but it does not have to be the principal use in a property that has multiple principal uses. That if the language is written to say the principal use, it actually precludes a property where there may be multiple principal uses. Okay, Nelson's nodding, so I didn't mess that up. Great. And in fact, you wouldn't be able to have your dispensary at the 7-Eleven because that would be an accessory use, right? Which the language we sent. So that was, just to say, that was the intent of what we were sending over in that regard.
Well, thank you, Counselor. I would suppose that it would, it would bode well if let me put it this way. Who is our probably least restrictive neighbor?
In terms of the nearby cannabis.
Restrictions. Cannabis restrictions,
Gotcha.
correct. While you mentioned Trinity and maybe, Councilor Lanahan and the council at large may not be privy to this, but maybe, how did we get this far that someone could go this far in the process and we not read, oh, by the way, you can't open?
No, they are opening. I think they're just the rare, in my opinion, rare applicant that's willing to eat half their building being empty in order to open.
And so this will allow them to expand eventually with some.
I'm not sure it actually does affect them. I think it would be moving forward. That's a key point, though. This would be not affecting folks that are in the process probably right now, but it would be new applicants. It would create more opportunity.
But Counselor, even so, there were no other constraints at the Charles Street location? Wasn't parking a significant issue that they couldn't support any other accessory business in there? So you've mentioned several times that, they can't use the building, but they can't use the building because they don't have the parking.
I think they fell short of the parking
Significantly.
to begin with, but our council made the judgment that on balance, the entire proposal still had merit. I'm seeing Councilor Crowe gesturing. I think it's in her ward.
Councilor Crowe.
And there was a lengthy discussion about the parking and about using the whole building. And if they were to use the rest of the building and it created a bigger, a larger parking, shortage, then they would have to find other parking. That was kind of written into the rule, that if they had to lease other places to make sure that they did meet the parking. So, so if they were to use the rest of the building and it creates a bigger detrimental parking effect, they would have to find alternative parking and have secured that parking to be able to use the rest of the building.
And as I understand it, it needs to be local. They can't secure parking too far away.
Exactly. So I think, the discussion was the CDBG garage or, some other places, but they would have to find other parking. Otherwise, it still would stay the way it is right now without using 40% of the building.
Right. Yeah. Okay, thank you. Eric Henry, are you all set?
Yeah, I think I'll yield at this time, Chair. Thank you.
Thank you.
Yes, if
Michelle.
I could just add, so we're talking about, for the public's reference, 36 Charles Street, which is a special permit 202-22 granted by the City Council. That particular property, to use the entire building, which was only approximately 11,000 square feet, required 52 parking spaces. They had 8 parking spaces on site. 8. So 52, and that's the same requirement for any retail. So this isn't specific to cannabis or marijuana establishments. That's the requirement for retail sales. So they needed 52, they provided 8. In the condition that the council's referring to was that they provide 5 off-site parking spaces. That's the condition of the special permit. There may have been discussion during the hearing about what they could do, but the only actual binding condition regarding parking has to do with that, providing 5. So I just want, 36 Charles isn't a strip mall. It's an 11,000 square foot building, and we can get into this more, but this paper has broad application. It's not just strip malls. It's any building where there can be multiple principal uses. In any of the districts, highway, business, industrial 1 and 2, where marijuana establishments are allowed. So it has broad application.
Right, so
It's not a limited application, and
Thanks for
Charles
that point
Street
of
is not a
clarification.
strip mall. The board's familiar with it because you made recommendations.
So do we-
And reviewed the plans. So I
Michelle,
just wanted to clarify that, and I do have the record if anybody wants to see it. Thank you.
Thank you very much for that clarification. And maybe you also know this, what is the traffic generation for one of these type of establishments?
Well, that particular case, interesting you asked about traffic, submitted preliminary traffic information that was peer-reviewed. They did not submit a full-blown traffic impact study. They were requested and recommended by this board to submit a traffic impact study. Our peer reviewer recommended that. So that was one of the recommendations that was made to the city council for this permit. And I do believe that is one of the conditions of the special permit. Let me get to this again. Yes, condition 1 is peer review petitioner's response to traffic peer review comments and implement any recommended mitigation. That was the full-blown study. So for that particular location, we are not certain what the traffic impact is. When they submitted the initial information, they only looked at the site drive. They didn't look at any of the adjacent intersections. And we recommended that they do that because how can the city council determine there's no impact to traffic if we haven't received the information and peer reviewed it? So that's why that condition was put in by the city council, so that that will be done. That is a condition prior to any occupancy permit being issued. Traffic mitigation has to be implemented.
Thanks all for the
After it's
points of
determined.
clarification.
thank you. Ken Antonucci.
Yeah, Michelle, you mentioned that this has broad application into other buildings and other zones. What are the types of buildings, if you give some examples?
Well, it's any building where a multiple principal use can be. So we heard about a convenience store, but the fact of the matter is, if the convenience store decides it only needs half of the building and the other half is open for rent, they could rent half of that. It would
As
be
an
a second
accessory
principal
use.
use, exactly. No, it wouldn't be an accessory
no,
use.
then
The
it-
accessory use is the convenience store selling marijuana on the side, like it's selling gum and other products. This is a separate standalone. So a business, it could be a restaurant, it could be a supermarket, it could be any other business in existence that decides there's space available. It could, I believe, potentially be Charles Street. That would be an issue for the building inspector to determine. But if Charles Street has 7,000 or 6,000 square feet vacant, and they're not using it, and that is proposed as a second principal use, you know, we'd have to look at that. So it's any building that could accommodate multiple principal uses. In the zones, exactly. In the highway business zone, industrial 1 and 2. Or the marijuana establishment zone, which is marijuana establishment overlay district, which is Upper Broadway.
Thank you.
Okay, any other questions for the sponsor?
And there are 17, just for the record, there were 17 parcels in the marijuana establishment overlay district. Those are all with Broadway addresses.
Any other questions? No, I mean, my comments on this is, I'm not in favor of wiping away all the principal uses and just allowing these establishments to go anywhere. The strip mall argument is certainly a compelling one. However, I would not want to see marijuana establishments subletting in other buildings with other uses around in the city. I'm just not in favor of that. The list that's in the staff report that goes through all the different options, I think it's there for a reason, and I think that it's good that it's there. Because what happens is, once we take away our ability to have a say in it, then a lot of things happen that we either may not anticipate or didn't think would happen that anyone would do that. So I personally am not in favor of stripping it away. I would be open if we wanted to cull out strip malls, but other than that, I'm not even sure about that I'm really 100% behind that, but that is more of a compelling argument than some of the other options that could crop up in the city for us. Those are just my thoughts. Risa Gray.
Thank you, Mr. Chair. I'm not sure who to ask the question to, but for clarification, there are 3 permits already in process. Does that mean there are only 2 more facilities that would exist under this? Okay.
That's only for
Michelle,
retail,
could
that's
you-
only for marijuana retailer.
Right.
There's a cap on the number of marijuana retailer licenses.
Okay.
Marijuana establishments, and I've listed this for you on the front page. Marijuana establishments, there's different categories. There's the retailer, which has the cap of 5. Marijuana, current cap of 5. Marijuana cultivator, independent marijuana testing laboratory, marijuana product manufacturer, marijuana research facilities, and marijuana transporters. Those are also types of marijuana establishments. So the regulations we're talking about apply to all of them, not just the retailer. So this would apply to the cultivators in the research facilities. Those could also be part of what I would call a co-location, or could be a second principal use.
So is there an unlimited?
Those are unlimited. There's no limit on the number of those, to my knowledge.
Thank you, Michelle.
Thank you. I think that's a great point of information, Michelle, that it's only the retailers that have the 5-unit caps, and that we could have cultivators and the manufacturers and the other stuff in any number that want to come to
I
Malden.
don't believe the city, was around for all the licensing and all the ordinances. We did not, to my knowledge, adopt any ordinance that restricts or caps a number of licenses for those other types of marijuana establishments.
And do you have briefly, what type of interest have we had? I've heard from the councilors that we're having trouble getting people interested in opening marijuana establishments in Malden. But I know there are 3 that have been approved, and haven't there been others that have pulled out for whatever reason?
Yes, if you give me just a moment, I was going through all these records to try to be prepared for questions like this, so, I did contact, the Cannabis, the City of Malden Cannabis Licensing Enforcement Commission. Nelson Miller is here, he's the chair, the building commissioner. However, the clerk, Kathleen Menning Hall, did give me a list of applicants to the Cannabis Licensing and Enforcement Commission. So that's the first stop in the process. They go to that commission. If that commission vets and finds them suitable in accord with all the ordinances, at the time, they will move them to pursue zoning relief. That's when it gets to the special permit phase. So this was the list provided to me. So this is since 2019. So there have been a total of 6 that the commission has moved forward to pursue the zoning relief. Of the 6, and there's a 7th that's pending approval, I'm told, next week. So there's another approval pending, the 7th. Of the 6, 3 moved forward with the zoning process and obtained special permits. Of the 3, 2 have building permits. Of the 2, 1 has a temporary occupancy permit. So they're moving forward, definitely. Those 3 I can speak to. On this list, however, are also all the other proposals that have been reviewed by the commission. Some, and I did ask specifically, what was the status? So some indicate no motion to move forward, so the commission didn't move them forward. Some were moved forward and decided not to move forward. One, for example, just to give you an idea, said, did not move forward, neighbors against. So, you know, there's some additional info I can provide. Some did not move forward, withdrew from process. It doesn't say exactly why. Some came back for second applications. So, some, you know, there's also a section that says reached out and showed interest. So there are, you know, there's a variety. Some of these are duplicates because, as I said, they've reapplied. But I guess if you give me a minute, I could tell you how many different applicants have been made.
No.
or maybe
It just
Nelson-
sounds like there
Nelson.
has been significant interest.
There's definitely, I would say there's definitely interest. It's definitely citywide. There are addresses on Eastern Ave, Broadway, Commercial Street.
I'll get you in second, Council.
Linehurst. So it seems to Madford Street, more on Broadway, so Eastern Ave, Charles Street we heard about. So there's definitely, seems to be across the city and
Now, one last thing, and then I'll go to Council McDonald. Of all those people on that list, were they all retailers, or were there a mix of the types of marijuana establishment they wanted to open? Can you tell?
most were retailers. There is one that was for a proposed marijuana retailer. Let me just make sure I have this right. This is in the staff report. Retailer, marijuana cultivator, and marijuana product manufacturer. That was moved forward to the zoning, through the zoning process. That was, for the record, denied the variance by the Board of Appeal regarding buffer zones. They are in litigation with the city, so I do not want to talk too much more about that particular case. That was one that was retail and these other components. There was also another one that was moved forward by the committee for cultivator, retailer, and manufacturer, so a similar three-prong business, I would call. That withdrew from the process. And I believe there was also another, okay, I'm sorry, that's a duplicate. That was the same one, the cultivator, retailer, manufacturer.
So there was only one?
There were two.
There were two, okay.
There were two that were retail, cultivator, product manufacturer. Both of those were moved forward. And then the rest that were moved forward were retail. So marijuana retailer was the principal
Okay,
marijuana establishment use.
thank you. Councilor McDonald, and then I'll go to the planning board members that are queuing up.
Thank you, Chair. I don't think, it wasn't my intent, and it doesn't reflect the discussions I recall at the council to say that we didn't have enough applicants. The point we were trying to make is just that our understanding, watching applicants move through the process and reading the research into cannabis business, the cannabis industry, and what it takes to open a store, is that the barrier is, the high barriers are exclusive to social equity applicants. And there's lots of research in the industry that backs that point up. So, you know, it's hard to know the folks who never applied in Malden, just as a point of fact. Just to say, I think that was our intent. Not to say that we didn't have enough applicants. I mean, I certainly didn't have a crush of applicants, but the Cannabis Licensing and Enforcement Commission is moving folks through the process, but the intent was to make an equity point about who can meaningfully have a chance to open up this business in our community.
Thank you, Councilor. Okay, the first person in the queue, Eric McCush.
Thank you, Mr. Chair. I think actually my question might have been answered, but I have, regarding retail versus cultivation. So a business could actually cultivate and have retail in the same building?
Yes, that would be considered two principal uses, two marijuana principal uses or an accessory.
So Trinity, for example, if they wanted to expand into their empty space, they could cultivate there if they could provide the extra parking?
They would need to come in to amend the special permit.
Okay.
Yes.
Thank you.
Or try to amend the special permit, and I presume parking would be an issue again.
Okay.
You're all set, Eric. Ken Antonucci.
Yeah, that was my question too, so you just answered it. Thank you.
Very good. Eric Henry.
Yes, just wanted to bring a point that I think Councilor Linehan may have been correct when she said there is no limit with certain regards to the number of establishments that can be petitioned to the city to have. And so with that, I think I'll yield.
Okay, thank you. Risa Gray.
Thank you, Mr. Chair. So can you also clarify the accessory establishments that are not retailers, they are subject to the buffer zone regulation, requirements and the parking requirements too?
Sorry, so the accessory,
Establishments that are not retailers, they
so
are,
accessory uses are treated as part of the principal use.
okay. So, maybe I'm misunderstanding that. So if the, you were saying like in a strip mall, for example, there's a convenience store, there's a space next door, they could not, with current regulations, they could not lease to a accessory use.
Well, it couldn't be accessory and it couldn't be a second principal use. So if there was a dividing wall down the convenience store, or the convenience store, was separated, or you have like what we're calling strip malls, multiple storefronts, like you have along Eastern Ave, there's a couple of them, there's 2 or 3 storefronts next to each other. So this is a principal use.
Right.
You can't do the accessory use under the current regs or what's proposed.
So if they were to be allowed, if this were revised, would they would be subject to the parking regulations
Yes,
and the
each
buffer
business
zones of-
needs its own
okay.
parking, right?
Okay.
So each principal use, we look at the parking for each principal use,
So
right?
they would still have those
Yes, so
regulations?
the convenience store would need its parking, and then who's ever in the other spot would need its parking.
Okay. Thank you.
This is no proposal to change the parking regs here.
Okay, Henry Susi.
Thanks, Chair. Michelle, just curious, is the primary use restriction, can a plaintiff file for relief under a primary use restriction through the special permit?
They can apply for a variance of that provision. They would go to the Board of
They could.
Appeal and seek a variance of the ordinance. It's not primary, it's actually called the principal use. Yes, they could petition.
Principal use, all right. And if I could just ask Councilor McDonald, you mentioned that the social inequities, it would appear that this restriction that we have here, I mean, is, in addition to keeping buildings empty, is restrictive on that social level. Can you expand on just exactly how that manifests itself?
Sure. Well, I think there are, 2 general points about this that affect social equity concerns. One is about the actual requirements that we have. And so in the case of the Charles Street one, right, there had to be an applicant who had enough financing and enough of a high-powered business plan to be able to pay the, pay the rent on 4 times as much space as they were actually going to use. And so it's hard to come up with that kind of capital, right? Or and the more options you might have within our reasonable restrictions about buildings, the more ways you might be able to make the numbers work, or balance other considerations in your business. The other social equity concern that the state has identified is about the process itself and the ways in which stretching out the process makes it onerous for applicants in unreasonable or unhelpful ways. Obviously, some ways are important. Public hearings, right? The ability to make sure that neighbors and those impacted by the business have a chance to have their say. But so for example, the difference between being able to simply apply for a permit versus having to go to the zoning board of appeals, the Board of Appeals to get a variance, might be thousands and thousands of dollars of time sitting on property, attorneys and consultants' fees and so on. And so those things tend to add up as part of the process. There are, the state is, this is not germane to the planning board, but the state is cracking down on a number of these things, including the way that cities may structure host community agreements, community host agreements, which are which have there's a lot of variation in what cities ask for and require. So I think we were trying to pay attention to both of those things, of what's a meaningful restriction that helps protect the community, but is not creating undue burden to the entrepreneurs trying to run the business, thus raising the barriers, and what creates important process points and what is creating hurdles that don't really change who can have input into the process, but just delay things or create more difficulties for folks without changing the outcome as much.
Thank you, appreciate it.
You all set, Henry?
All set, Chuck.
Thank you. Eric Henry.
Thank you, Mr. Chair. I'll take my last to say, so Michelle, you mentioned all of the permitting that have been through the process, and the council also mentioned that the further you go into the process, the more financially the cost is going to be. So of those projects that did not get to the finish line, which ones were most closest to the finish line? How much equity did they invest, if you will, to get to that point and not capture the prize?
Yeah, I don't have that information.
Okay.
I have information on who were the social equity candidates, who were the women-owned businesses, who were the economic empowerment candidates that were approved and moved forward. So there, we're not talking about that, but there are in that group, and I've noted this for you, of those special permit grantees, one is a women-owned business. That women-owned business is one of the state's equity programs. There's social equity, there's economic empowerment equity, and then there's this third program called minority-owned, women-owned, veteran-owned businesses. So that clearly met that particular criteria. There are also, another petition approved to proceed to zoning was considered a social equity applicant. Now that's determined by the state, just so you know. The state determines whether you're, quote, social equity. And I will add, and I'm not an expert on it, but it's my understanding that it's not just based on finances that make you a social equity applicant. It may kind of lead you to think, oh, the person doesn't have any money, they're social equity, but that's not what the criteria is to be classified as a social equity, to my knowledge. And again, I'm not an expert on it, but what I've read from the state guidance, that's not the consideration. It's whether you've been impacted by the war on drugs, the marijuana prohibition, disproportionate arrests and incarceration. I'm not saying there's not a connection to finance, et cetera, but it's not specifically a financial inquiry. And keep in mind that the CLEC, our own city licensing commission, fully vets all these applicants. So they would not be moving them forward if they did not, they're not financially viable.
And not to imply that the applicants are the ones who who have been in the system, or those things apply to. It's them as a member of a race.
But they still do have to have the money to do the project. So
Yes.
it's not that the individual necessarily has the money to do it. They have the financial backing to do the project. So there's a little bit of a difference there. But I also wanted to note that regarding the 7th application pending approval, one is a social equity applicant and one is an economic empowerment applicant. Also, since we're just talking about this, I want to just bring briefly to your attention a paper that the City Council passed as part of its original licensing ordinances back in 2021, which I believe probably Councilor Crowe was the only one on that in this current group, but probably maybe the others are familiar with it. Just give me a minute to get to the paper.
Yes.
But I think it's important so you can understand, if I can find it, here it is, what Malden has been doing. So this is from June 29th, 2021. This is paper 285 of 2021. This was ordained that at least one of the licenses preference shall be given to an applicant where at least 51% of the business is owned by a resident of Malden who has been a resident for each of the past 5 years, or an applicant who would qualify for the Cannabis Control Commission Economic Empowerment Priority Review, or the Social Equity Program, or a minority-owned business as designated by the Commonwealth of Massachusetts. And that was passed unanimously by the council in 2021 when we were already, now, the original ordinance was in 2018. That's when we put the book, licensing and ordinance on the books.
Yes.
This was in 2021. So we have been looking at this, and the city council has been looking at it over the years. So just wanted to note that.
And I appreciate it. It seems that we do have a couple of wins for social justice, social equity and along the way already, and that's great. But also to the council's point, you don't get this far in the process, even if you're a social equity candidate, without without a very solid plan, and all things being equal and, being more lucky than good, you'll get it across the finish line. But unless we're in our process, is it something in our processes that have stymied the applicants such that they, had it not been for this, they could have taken this project across the line? It has to be a considerable amount of, like you say, layout of resources to get to that point. And if we're considering that these papers are barriers to that entry level, so be it. I can support that, but it seems that there are probably other barriers that the council is admitted to. I mean, from my understanding, and I was just wondering about that. And with that, I'll yield. Thank you.
You guys can leave it on. I keep.
So I guess a couple of things I would say is that, we had certainly hoped to touch on, we started out really big when we were looking at all of this, and we had hoped to touch on a number of other issues, particularly thinking about what the state is going to really come down on us for. I think, down the line, we're not going to be able to charge the same type of fees. We will be more readily penalized if, we end up on the more restrictive end compared to other municipalities, and social equity or economic empowerment candidates are sort of flaming out partway through. I think we had hoped to have a more cohesive package, but the legislation moved a little bit slower than we wanted to move to try to address some of the things locally. That's why I had said a little bit at the beginning, I anticipate another batch of proposals. But the other thing that I would mention is that, thinking about it not just from the equity applicant's point of view, but from maybe the Malden landlord or property owner, that, as soon as something enters the process for a piece of their parcel, effectively the other tenants or other principal uses or accessory uses right now those tenants can't stay if they're going to be able to move forward with just the cannabis applicant. So I think, obviously we're not here to look at one point of view more strongly than another, but there is a case to make that you're not just disadvantaging those applicants, but potentially the folks who actually own those buildings and have to clear them out or can't renew rent to a principal use adjacent to a proposed cannabis business in the event that they make it through the process. So that's another thing that I've been thinking about. It's for sure the lost tax revenue. It's definitely it's the revenue from the cannabis itself. It's the tax revenue on the property, but it's also affecting, I think, the neighbors and the folks who own those buildings while this protracted process takes place. I think some of the other things that we're looking to do here, which on the face of it look like just language adjustments or small procedural things, the goal is to speed up the process and make it easier to understand so that when folks come before the CLEC, there isn't this back and forth about, I needed to get this building permit, or the state said this, but your ordinance says that. We're trying to look at things holistically based on the feedback that we've gotten, and when we get to those other items, I think I will actually invite our building commissioner to just come up and speak a little bit, because he was able to articulate in our committee very well what they've run against on the CLEC as applicants have come in and what specifically slows things down. But I think Councilor McDonald really hit the nail on the head, in just that the longer the process takes, the more capital you need to have available. And in a market like Malden, that's a tremendous amount of money no matter which way you slice it. Correct. So as Councilor McDonald just pointed out, the other things before us tonight actually come to us from the CLEC, so it's in response to kind of learning from how things have gone and how we can do better.
Thank you, Councilor, and I certainly applaud anything that would make the procedure more clear for those who are trying to undertake it. But isn't part of that they understand what the requirements are and they tailor their search to meet those requirements? Because what worries me is the things on Beacon Hill can be very fickle. And they want to change something, or there's different things that come up, or people see it as an opportunity for a money grab, so they start easing things. I'm real concerned about abdicating our ability to regulate and to control what's coming into our neighborhoods by stripping everything away.
Well, I definitely don't see it as stripping everything away. It keeps the same limited number of zones. It keeps essentially it's a marginal increase in the number of parcels. Again, it's hard to quantify for the reasons that Councilor McDonald and I already spoke about. Just again, we have so many more restrictions than any other municipality in the state that to actually layer enough GIS layers on and get an accurate assessment and look at all of the dimensional controls and everything else that have to be considered, it is just hard to get to a number. But, I definitely wouldn't think about it as blowing up the number of sites. I think it's a reasonable, very measured approach to open up, frankly, looking around the city, some parcels that don't have anything in them right now and could be bringing in tax revenue. What I get complaints about from constituents is the process seems slow, we need the money, and particularly as a public school parent, our resources are not great right now. So we have the ability to leverage this tax base, and I think our process is holding us back. It's not meant to take away voices from neighbors. It's not meant to, as I said at the beginning, it's not doing anything with the buffer zones. It doesn't put things closer to schools, doesn't put things closer to residences. It puts things exactly where they would otherwise go, but it puts a few more parcels on the market that makes that cost a little bit more accessible to, local, but even not local, just not conglomerate, huge investment firm backed, outside of Massachusetts type of operations. One of the things that the state is going to do is really clamp down on what we can ask for from applicants. So, in terms of the money grab that you referenced, I agree, that's been a problem here and other places. I think, we rightfully don't know what we're getting into and we want to ask for as many things as we can. The state has recognized that that is holding back the ability for a lot of equity and economic empowerment cannabis candidates to move through processes, not just here, but in other places as well. And so based on the legislation that has just been signed by the governor, we are not going to be able to ask for that type of money and that type of mitigation. In my mind, that's even more of a reason to enable locally owned businesses to succeed because they have more of a stake in the community. They'll be more willing to do those things without having to be asked or have it put into a special permit. That's my opinion, but I think anything that we can do to help, our own Maldonian businesses or locally homegrown businesses to succeed, I do see that as part of what we should be doing here, and that is really the motivation behind this.
And do you have you mentioned something about the money we won't get. Do you have an idea what the magnitude of that is?
I don't know that it's possible to quantify that, but I think the sort of basics of municipal finance that we all deal with is that new growth is really our path to exceeding the tax levy that we are able to, take from the properties. Massachusetts is very, very restrictive, and to the extent that we can invite businesses and new development to come in, that's really our only leverage point to grow our tax base. Yeah. I think a vacant business is bringing in nothing or close to nothing, and if anything went there, it would be better than what we have now, and it also just contributes to a sense of, blight, abandonment, and that's not a great place for subsequent businesses to come into. So I think to the extent that we can fill storefronts with responsible businesses, which I have no doubt that anybody who comes through this process would be, I think it helps the greater ecosystem of businesses and our economic development as a city as well.
Okay,
Yeah,
no,
go for it.
I was just wondering, in all the meetings you had with Ron Hogan, had he not modeled this, he's pretty financially savvy, and I would have thought he would have modeled and had some range of what we were looking at, how much we could expect, how much we were going to be able to pump into the school systems or the fire department or police. But Councilor McDonald, you were going to say something?
Well, I hesitate to even hazard a number, but I think we're in, 6 figures of revenue per business, per per retail location were the kinds of numbers that I was seeing. I was just trying to see if I could pull up one of our neighboring cities, and how much money is Melrose getting from their, dispensary that is right across the border that many Malden residents go and.
I sit in traffic enough waiting for the
That's
people to
right.
go in and out there.
That's right. Spread the wealth a little, Melrose. But I just want to zoom out for a second and point out that marijuana establishments are the most onerous business to operate in Malden, and that's not going to change with any of the things that we put forward isn't going to change that. I mean, they have the CLEC only does, shepherding and oversight of these applicants. The applicants, it takes a lot to get through. It's a long process. I mean, there's very few special permits anyways, right? So I just want to note that, there's no version of anything that we would put forward from the council, I think, that would change the integrity of what we expect from applicants. And even if all of the things that, we sent to you ultimately went through, it would still have more checks than any other type of license in the city, as far as I know.
Thank you. Ken Antonucci.
Michelle, how is, for the multiple use applicants, the ones that you mentioned, if you're a cultivator, manufacturer, transporter, is one portion considered the principal and the rest are considered accessory businesses?
It could be. I haven't seen one of those proposals. They've filed with the CLEC, but they have not come forward through the special permit process, so I haven't had a chance to review anything in detail. I'm not sure if they were all principal uses, if they were accessory uses. I don't have the info for that. But keep in mind, all these vacant storefronts throughout the city, any business can go in there as long as they have the parking. Essentially, that's what's left of a lot of the zoning, since we've eliminated a lot of the special permit requirements. So the fact that there are vacant storefronts and businesses aren't going in that don't have to go through this process is really another issue. There's no prohibition against multiple uses in any of the strip malls or any of the other businesses, any other buildings. I mean, you can have multiple principal uses in any building. So when you do see vacant storefronts, it's not just because our marijuana ordinance is too restrictive. I mean, there are other issues going on. This board's familiar with all the changes we've seen over the years to loosen all the restrictions on special permits, so there can be an interchange of the mom and pop stores. Down on Bell Rock Square, there was an issue. Retail service can't change to sales, can't change to offices. Now there's a broad interchange among all those types of businesses. They all have the same parking, they all have the same dimensional controls, and for the most part, they don't need special permits anymore. Even recreation for gainful business is another one we've recently added. So the city's definitely loosened its restrictions on all these other business types. I think there are vacancies in the city. I think the rents are high in the city. One of the councils mentioned that. I mean, this is the state we live in, and this is the proximity to Boston, et cetera. So I think there are other factors involved. I do just want to note, and I don't have all the details, but I did hear, informally from Nelson Miller when we were talking about who's been reviewed by the commission, the CLEC. I don't believe there were any multinational conglomerates that have been applying for permits, but he can correct me if I'm wrong. I don't believe any of the three that were granted permits were these large multinational conglomerates, as they say. So, as I said, one was a minority-owned, woman-owned business, and we have info on the others. So, I mean, I'm not sure about that sense of that's who it's limited to, based on the regs.
Ken, are you all set?
Yes, for now, thank you.
Councilors, I was wondering, I was just thinking of this. I'm hesitant to say it because I read it a year or two ago, and I don't know if it's still accurate. But I had read somewhere that to open up a marijuana establishment, you needed in the range of $2 to $3 million.
Oh, I bet more, actually.
This was back a few years ago, and it was a big study out of Colorado, and whatever they call it, Weedathon or whatever. There was some big social convention where they were bringing all these people, and they had all these little fun stats right around the time that we were adopting this stuff. And I was just curious if you had any more current information on it. Because I find it hard, how is any social equity people gonna come up with $2 to $3 million? How's anyone, let alone social equity? So,
Yeah, I agree. I mean, I definitely don't, off the top of my head, have any updated data, but, you know, thinking through some of the proposals that have come through, I think that's definitely the basement that you'd reasonably expect. And if that's a median from a national conference, there's no reason to think that Massachusetts wouldn't be on the higher end, right? Just because the cost of doing business here is high for everybody, cannabis or not. I don't know. What's the answer to that? I don't know. I mean, I certainly couldn't come up with that kind of money if I were in that business or any business. You know, it's an unbelievable barrier. So I think it's part of what I'm inviting others to envision with me here is just a community where we can lower those barriers. I think the quality of the applicants is not going to suffer. It's just the type of access to capital that they can raise, which, you know, it just defies expectations that anybody would be able to do that in this market. I think the more that we can do to enable the equity applicants, it's not just going to be required by the state. I think it's the right thing to do.
have you guys heard anything about the state taking a role in this? Let's throw the number 2 million out there, whether it's that or not, or something higher, maybe a little bit lower, whatever it is. The state's loosening. Governor Baker,
Yep.
you know, did some legislation or enacted some legislation last week that relieves a lot of this stuff. Is he also going to back it up with some sort of funding program that if you are deemed a social equity or one of these other protected categories, that they're going to help you with funding?
So my understanding of the legislation is that there will be a pool that social equity applicants can access. But again, our applicants wouldn't be able to get that if our rules are so restrictive that we're not welcoming, if for lack of a better word. And I think that what we stand to lose is an extra percentage of revenue. They fell short of taking away all of your local revenue. That was actually the initial proposal, that if they deemed you too restrictive, you could lose the revenue from even the ones you've already approved. Luckily, I think for us, that didn't make it through. You know, that was, I think, the extreme initial proposal, but there is certainly a bonus above and beyond that we would lose out on if we are found to be not allowing enough equity applicants. And I'm not really sure, honestly. We're still, Mr. Hogan and I are still kind of analyzing, you know, how do they determine that? What's the metrics that they're going to use? Is it a percentage or a proportion of your approved licenses, or is it in any way or in relation to the demographics of your community? That piece I don't know how they're going to actually measure whether you comply. But again, the analysis that we did in our committee with Mr. Hogan's help around where Malden stands in the state is that we are definitely in the top 5 most restrictive in terms of all the regulations that we place on cannabis. So it's, you know, my fear is that if that's what the analysis that we've done kind of back of the envelope shows, that we're not really putting ourselves in a competitive advantage to make use of that additional social equity money, which I think we should, you know, absolutely maximize the revenue that we can experience. I don't know if you
But
have
we don't
anything
know
else.
what that amount is.
You know,
We talking $10,000 or 10 million?
So the percentage that I had heard was an additional 3% of revenue above and beyond if you're licensing social equity. So I don't know if that's a proportion of that goes into that pool or if that's just straight revenue that you would get, but it's a bonus bucket of money that you would get if your rules are deemed to be welcoming and accessible enough.
Okay, thank you. Any other questions? Ken Antonucci.
Yeah, so either one of the counselors, you know, we spent a lot of time talking about the equity applicants. Pulling back to this particular paper, how does this particular paper and changing it like disproportionately affect the equity applicants versus any applicant trying to come in?
So it won't change the process. The process that everyone goes through would remain unchanged. And if for equity applicants, you do get, you know, a greater consideration. I think the point that we're trying to make is that, as Councilor McDonald had said early on, we're surmising that an equity applicant, you know, being a not venture capital backed most likely, or just local or small or what have you, may not have access to the amount of capital that's needed to compete with these larger properties that are essentially what's left if the principal use, I feel like I'm still saying that wrong, the principal use restriction is still in place. So if you're only looking at very, very large or off-market properties, the amount of money that you have to bring to the table is just going to be higher, and that would affect a number of disadvantaged groups. But even if you just restrict that to the definition of what a social equity and economic empowerment applicant is by the state, that's not a definition we make up. That's something, as Michelle said, that is imposed on us. It's a very strict classification that you have to get a certification to actually comply with. I think it just stands to reason that the more mom and pop, the more smaller, the more local, the less competitive you are if the market is restricted in such a way that you're only looking at large parcels or expensive, or, you know, you have to know somebody because it hasn't even been listed type of a situation.
Okay.
You all set, Ken?
Yeah, thank you very
Eric,
much.
and-
Thank you. It was a good answer.
Okay, thank you, Mr. Chair. Just point of order of information, if we're more than anything. I know we're going to vote on the papers individually. So are we limiting our discussion at this point only to 316?
At the moment, we
Okay.
are, and then what will happen, when there are no more questions about 316, we'll go to 317, 318, 319, and then when everyone's questions have been heard and answered, or as best they can vetted, then we will open it up for those that will speak in favor for any of the four, or in opposition of any of the four, and then when we vote, we will vote on each individual paper.
Okay. Yeah, I understand, I don't really find it that difficult, hard to find people who are social equity people to be able to get into this market. If you have the capital, you have the capital, you have the drive, you have the plan, you're gonna get that way, so. All right, and then with that, I'll yield.
Okay, thank you. Are there any other questions? Counselor?
You know, I just wanted to note, I mean, I'm mindful of the, you know, the planning recommendation that you all have in front of you, and I do think that, you know, it's reasonable to limit certain types of principal uses that could be co-located on the property. I think, I don't understand why some of the items on this particular list are included. Seems like some of these businesses could really help each other out, frankly, but, you know, I want to also I would, if we were going to restrict certain types of use, I would just want to make sure that we're not duplicating either state requirements that would already preclude, or other parts in our ordinance related to buffer zones and so on. You know, we have a buffer zone around, I mean, daycare and educational facilities already. So I think I can't imagine a property that would have multiple principal uses where that would be permitted anyway. So I just didn't know if you are discussing these, if there's opportunity to understand more what these different, why to include certain elements or certain other types of uses in a list of principal uses to consider or not consider on the same property as a marijuana establishment.
Thank you. Peg, did you have something? Any other questions for the councilors on the paper?
Offer
Michelle.
2 pieces of information. I do have a copy of what the governor signed this past week, and I believe the number is 1%. That's the number that is written into the law. If the marijuana retailer is a social equity business, we would have to go through a certain certification process. So if we have at least one marijuana retailer that's a social equity business, that is the percent.
We'll get
The
an additional
1%.
1%.
Yeah, I don't know exactly how it's calculated.
Of everything, or just that?
Well, this says at least one marijuana is social business in proportion to the amount of sums received from the sale of marijuana or marijuana products by any such marijuana retailer in the city or town. It appears to apply to that marijuana
okay.
retailer, not all of them.
Okay.
So, again, I'm not an expert on this, but I also did want to mention, because somebody asked, is there a fund or is there assistance? This law, that was recently done, also establishes this social equity, what is it called here? Social equity, Cannabis Social Equity Trust Fund. So social equity applicants can apply for assistance. It listed training, technical assistance, skills-based training, tools, licensing benefits. There's going to be a fund set up.
But no capital funding.
That I don't know. I don't know, but my point is that the state you asked, is the state doing anything? I think they're doing something. I don't know the
Yeah,
parameters
I
of
was
it, but there
thinking
is
more,
something.
are they gonna get any money
Yeah.
that these people can access at a reduced rate or something like that?
Right.
But,
And,
okay.
I mean,
you
I
all
don't
set,
know
or-
I don't know if you want me to address Council McDonald's question about the list that I included, or you want to wait
yeah,
to
why don't you do that, and then we'll
or,
go to
I mean,
Kenny.
I could just say that was just noted, that's just for your consideration. It's not a definitive list, it's not an exclusive list. My concern is, and we're not doing the hearing yet, I should say, about paper 315, but there is a proposal in paper 315 that would potentially substantively and significantly change the buffer zones. And if that paper is read in conjunction with this paper, you could possibly have exactly what Councilor McDonald just referred to. Because that paper would allow again, without getting into the details, would allow the potential to reduce or completely eliminate the buffer zone. If that happens, there's no reason why we couldn't co-locate. There couldn't be a proposal for that. The only thing in the state law, and you asked about the state law, the only buffer zone written to the state law is for schools. All the other buffer zones that we have, residential, religious facility, et cetera, those you can see reflected in the list. The buffer zones are in there. So to Council McDonald's point, that portion of our ordinance, there's a proposal to change it. So whereas this is going forward, we don't want to lose the opportunity to make sure these issues are addressed. And now, because it's not going forward tonight, you're not actually going to be considering the other, but we won't know, even if you did, how the council ends up. Once it leaves you, it's left you. The council is then going to decide whether or not to ordain it. So this would be your chance. So that's just a list. I went through the entire table of use regulations, and I looked at uses, obviously, that I thought could potentially, as it says in the list, and as it says in the note, potentially be incompatible or in conflict with a marijuana establishment, and not just a retailer, any marijuana establishment. Keep in mind, this ordinance applies to all marijuana establishments, not just retailers.
Okay.
So I looked at places where people congregate, where children congregate, where families congregate, where there could potentially be youth congregating, and that was a serious concern of the council when this was ordained. That's why there's a buffer zone regarding parks, playgrounds, YMCA, MTech, teen center, et cetera. And I just, motel, hotel is quasi-residential. Nursing, convalescent home is quasi-residential. This board's permitted assisted living under that category. So I also tried to include some that would potentially be considered residential, because if we just say residential, it's not going to include some of those other, what I call quasi-residential. The convenience stores, the supermarkets, things like that, again, given the potential for sale of alcohol at any of those, also restaurants, et cetera, tobacco sales, other regulated drugs, if you will, that's how I came up with the list. Again, it's not a definitive list, it's not meant to be exhaustive, it's meant for your consideration to, think about if this principal use restriction ends up moving forward, are there places you would not want any of those 6 marijuana establishment categories to potentially co-locate, at least I should say by right. There's always still the option to apply for a variance, but this opens up the door for what I would call the by right siting.
Thank you.
Thank you.
Kenny Antonucci.
Michelle, going back to what you were speaking to just before that, that 1%, you mentioned that we would be able to get that if at least one of the licenses went to an equity applicant. Is that just a social equity applicant, or does that include the MBEs, WBE, VBEs?
Well, this says social equity business, but it's not in caps, as defined by Section 1 of Chapter 94G. So I don't know. I don't know if that encompasses all of them or not,
Or
but I
just a
do know
social
that that is
equity
one of the new provisions. It was pointed out by Mr. Hogan that there would be an additional incentive if we license social equity. So again, it's an incentive. It's not a requirement. It's an
Right,
option. If
right.
we do
But
it,
it's more
we can
funding,
get
more revenue.
additional
access to
Money.
more revenue.
Yes, additional
I'd
revenue.
like to get a hold of Mr. Hogan's projections on these things, if he's able to share them with us. Just
I don't have them, I'm sure the council has them, I was not privy to any
Yeah,
of that.
and I'm not
so.
sure that's records that they want distributed either, so, but Ron should have done some analysis to gauge his stuff and these things that he's proposing. But, are you all set, Ken?
Yes.
Thank you. Risa Gray.
Mr. Chair. Michelle, is there an opportunity during this meeting to address these use types on the list that was just discussed?
I mean, yeah, it's up to the chair, you can do it during your deliberations, you can do it, I would say you definitely want to do it. I did incorporate that list into the recommendation, so before you take a vote, you should definitely have discussed it and deliberate to decide whether you want to include all, some, or none, or
Yeah,
add
why don't we
new
do
ones,
that
so-
during our deliberations?
Yeah, I mean, you can
When
do
Michelle's
that.
going through the staff report.
Thank you.
And
Thank you,
so
Mr. Chair.
I think
start-
you're gonna do
start
them
thinking about
individually.
anything you want to pair up. Okay, any other questions? Ken Antonucci.
Sorry, to go back to the procedurally, what we're gonna do tonight, so we're gonna go through each one, go through all the discussions, have our discussions on each paper. Then it's gonna go out to the floor for public?
No.
We're going to go through each paper, ask questions of the petitioner, of the paper
Sponsor,
proposal.
yeah.
Right.
Then, when we get our questions and go through all four of them, we will then go for those that want to speak in favor, and then those who want to speak in opposition, at which point we will close the hearing, and then Michelle will take us through the staff report, and we will vote individually on each of the four papers.
Okay. Thank you. I'm just thinking
Okay.
how I'm going to remember anything about this paper.
Refer to the staff report.
No, I know. 5 hours
Okay.
from now when we
Okay, Eric Henry.
You're going to refer to your copious notes there, I know, Ken, of course. Seeing no other lights, maybe to make a motion that we can move the debate to the next paper. I don't know if that's the proper one.
Well, as long as no one else has anything.
I don't see any lights.
Well, let me see who shows up here, Eric. So you're all set. You don't have any other questions. Very good. Are there anyone else who has any other questions on paper 316? No one? Do the councilors want to make any comments on 316? No? Very good. Then what we will do is we will then move on to paper 317. So if Councilor Linehan would take us through 317.
Sure, and I do think this is a whole lot simpler and straightforward. This is basically looking to condense language and make more clear that the police chief and the CLEC approve the security plan. And then if you look at the legislation details with the inline edits you can, in your packet, you'll see how the previous wording is just, it goes through a list of elements that are redundant to what the state requires and are just like a little bit too wordy. And so this is just really looking to streamline that and make it simpler and, like I said, condense it. I don't know if any of my fellow colleagues or if Nelson has anything to add, but that is the basic gist of it. And again, this did come to us from the CLEC as a wording suggestion change that we could package up with the other items that we're proposing.
So if I understand this, Counselor, what the intention is to take it away by eliminating the itemized elements and leaving it up to the Malden Police Chief and the CLEC group.
That's correct.
And what will they use as a criteria?
So
If they
again, this
don't
is where
have
I
any
might look to.
itemized numbers, if they don't have any itemized guidance, what are they going to use?
So my understanding is that these things are very clearly listed with the state and that they're already in compliance with that at the point that they come to us. So it's, Nelson, do you mind coming up? He can probably describe better how this has played out, but I don't think that we're taking away the right to discuss certain elements or be unspecific. It's just, again, to clarify that text and not be redundant.
Right, because Mr. Miller, what my concern and next question is going to be, what happens when the state changes it? If we abdicate all our ability to regulate and then we rely on the state, and then the state changes it. Where are we at that point?
So the security guidelines for these locations are already established by the state, and the CLEC is made up of people who have specialties in certain things. Obviously, I'm on it because I'm the building commissioner and zoning officer. The police chief is on it because he's the expert when it comes to the security for buildings. So what the police chief is doing is verifying that these proposals are in compliance with the state laws. So there was a feeling that it was redundant to have that done twice when the applicant, when they arrive to the city council for a special permit, have already gone through that vetting process. The police chief has already confirmed that their proposal is compliant. And then on top of that, prior to all these locations opening up, one of the steps that the State Cannabis Commission takes is they have to come visit the site, and they have to confirm on their own that it's compliant with their rules regarding the security. That's not to say that the police chief can't have any additional, requests or suggestions for a location, but the minimum right now would be the state law, what's required by the state.
And what do we do when the state changes it and makes it more permissive?
We would comply with those rules, and then if the police chief felt like they had, they wanted to add additional rules, the police chief could do that.
What would CLEC's role be in it? What would they be guiding?
The same guidance we have now, the state law, and then the police chief's expertise as the police chief.
So CLEC equals whatever the state law is?
I'm sorry?
The CLEC team would be just looking to only whatever the state requires. And it would be on the police chief to do something more over and above. If, for instance, there was a rule that was enacted now, then 6 months from now, the state says, yeah, let's get rid of that. We want to get more money out of people, so we want sales to increase, so we're going to eliminate that. And then what would CLEC's role be? Would they say, oh, no, that's just too much, we want to protect our neighborhoods more? Would they go and recommend that as part of their review, or are they just going to say, what's the state require? They meet that, we're good with it?
Yeah, so my belief is that the reason that the police chief is a statutory member of the CLEC is so that the police chief can play that particular role on our commission, just like I play the particular role of zoning, building, that end of it. Ron Hogan, who's the member that represents the mayor's office as a person with a financial background, he focuses on the finances, do they have the money to do this? So the reason the police chief is a part of the CLEC specifically is to review it for its security layout, for its compliance with the state law, but also with whatever the police chief feels that particular location might need. If it's in a particularly, different location in the city, he might want to have more cameras because there's a higher amount of crime in that area or something like that. I don't know. It's up to the police chief to decide exactly what that overall security package is. At a minimum, it has to comply with the state, because at the end, the state comes in and they won't give them a license if you're not in compliance with their rules. So that's the minimum barrier, is compliance with the state law. And then
Right,
the chief,
and I'm not worried about that one. I'm not worried about that end of the spectrum. I'm worried about if the chief sees, hey, we should do this. Best practice indicates we should do this, but the state doesn't require it.
The police chief can still ask him to do that.
And
I would argue that the police chief also would be the person that the city council would rely on for that information. I wouldn't say the city council is necessarily experts on security for, well, maybe not at this point, but I guess there could be a police chief on the city council. So the police chief would be the resource to both the CLEC and the city council with regards to, is this particular location compliant with their security plan?
Right, and I have every confidence in the chief in doing diligent and thorough review of these things. I just was curious what CLEC's role was in it and what the chief's role was in it.
The security plan is one of the things the CLEC has been specifically charged with reviewing when reviewing these applicants. We're there to review their location, their security, and their business plan, generally speaking. We can look at anything we want, but those are really the main points that we look into for each applicant.
Thank you. Ken Antonucci.
Yeah, I was hoping to add to that before Commissioner Miller walked away. You don't need to walk back up, but just to make it clear that the local authority can always be more restrictive than the state mandates, right? The state is a minimum.
I'm sorry, making my notes.
Yeah, this isn't one of those things like the building code where we as a city can't make the building code more restrictive, right?
Right.
It's guidelines for licensing. So if the police chief wants 5 cameras and they're only supposed to have 4, we can make them have 5 cameras.
Right, and I think, Mr. Chairman, your concern was by getting rid of this, what's basically a checklist of minimums.
Right.
Making sure that someone would still, on the city's part, have that checklist of minimums to go through. And I think the assumption is that the police chief and CLEC are going to have those tucked away. It's not like someone's gonna forget, oh yeah, well, we didn't include a security guard on site or whatever. It's like.
It's one of the particular things that we look at.
Right, so again, this is just to eliminate the redundancy and kind of streamline things.
Right.
Thank you.
Thank you. Oh, Eric Henry, I don't know, Nelson, if Eric has a question for you.
Actually, first one's part of order. Mr. Nelson, can you please state your name and address for the record?
Oh, I'm sorry. Nelson Miller, Building Commissioner and also Chairman of the Cannabis Licensing Enforcement Commission, City of Malden.
Awesome. So it seems to me it's two things at play here. The elements of the plan when it was as it appears as a zoning issue, and now we're talking about shifting it to a licensing issue, if I'm following that correctly. I just wanted to know what was the point of deviation from the elements that the Malden plan had that we were required to the current state plan? What differs?
There really was no deviation. When the City of Malden started to put together our cannabis regulations, there really are no rules from the state as to how your licensing process is supposed to go. So there were a group of people that put together the CLEC and put together the rules of the CLEC without any real guidance at all, other than the state laws surrounding cannabis licensing, and knowing what the final step was going to be, meaning what the process was to go through the State Cannabis Commission. We utilized that to make sure that once a candidate got through our process, they essentially had done all the pieces and parts that they had to do to submit their nice final package to the state and get licensed. So, I don't know if that's the answer you're looking for, but there is no deviation from any set of rules because there are no rules. We made the rules.
Thank you.
Yep.
Okay, any other questions for the sponsors or Michelle? This one certainly, and the next two also seem to be a lot more straightforward than the first one was. But, okay, if no other questions for anyone? Do the councilors have anything they'd like to share? Or ask, or do anything? No? Okay, let's move on to paper number 318. Councilor Linehan. Oh, I'm sorry, did I shut you off again? Dang, you guys gotta stop shutting it off. There we go.
Thank you, Mr. Chair. And after this, I get to put Councilor Crowe on the hot seat for the final item. So again, this is pretty straightforward. This is looking to correct what we're calling some procedural issues. It really is looking to update the text to reflect our current practice around how we issue the final occupancy permit. I think there were elements that are a little confusing right now, telling applicants that they need, a building permit prior to getting their license and approvals, when in fact you need those before you can be ready for occupancy. And so this is really trying to tidy that up and correct some of those procedural and wording problems with the current language. And I would again invite our building commissioner to come up and elaborate if, or if folks have questions about that. But it's trying to make sure that applicants aren't kind of caught between two things. They can't get one step before they've achieved another part, make that kind of more clear what has to come first, and then adding that word final occupancy permit to make it more clear exactly what we're talking about.
Yeah, so what Council Lund had said is exactly correct, and it kind of piggybacks on what I just said about when we made these rules. We weren't necessarily in tune with what the whole process was when these rules were put together, so we had some steps in the ordinance which got reversed. The way the process works, the linear path to becoming in a retail or any marijuana businesses apply to the CLEC, get moved forward through the CLEC, then any kind of variance you might need, and then to the city council for a special permit. Once you have a special permit, then you can get a building permit, then you can build your location. Prior to getting licensing from the state, you have to have either an occupancy or a temporary occupancy to get to the licensing process. So we had some of those reversed where we were putting the contingency on getting your license prior to an occupancy. You can't do that. The state won't allow that to happen. So these changes just put all the steps in order. It doesn't make it any harder or any easier. It just puts all of the steps in the correct order so that we don't have a contradiction in our ordinances relative to the way you actually have to abide by the process.
Ken Antonucci.
I'm sorry, Mr. Miller, can you go through that again? I mean, I like the steps, you know.
Sure.
Just to clarify.
Cannabis Commission, we move you forward. We don't issue a license, we move you forward. If you need a variance, you get a variance. Once you have that, you get your special permit. Once you have a special permit, I issue you a building permit. You build your location. When you get to the end, you then have to report back to the state Cannabis Commission. They want to see an occupancy certificate from us to do that, temporary or final occupancy. So 323 Commercial is the best example. Misty Mountain, they're the closest to opening right now. We've issued them a temporary occupancy certificate, and we've done that so that they can get on an agenda with the state, where the state now comes out, reviews their location, looks at their security plan, so on and so forth. They will then approve them, report back to the CLEC, and we as a CLEC will issue them a license. So the license is the last thing that happens, very last.
Okay, thank you very much.
Yep.
Eric Henry.
Thank you, Mr. Chair. Mr. Miller,
What?
how long that process took for that candidate to get to this temporary license?
For Misty Mountain?
Correct.
Michelle, you have it on the list when they were approved?
And when they initiated too.
In the way of defense of the Cannabis Licensing Enforcement Commission, we saw our first candidate in June of 2019. We reviewed 17 proposals between June of 19 and last week. We moved 6 proposals forward. That's one more than we're allowed to move through because of some bailed out or whatever. So, and we had a little bit of a pandemic in between. So I would challenge anybody who says that the city has been slow in moving these candidates through. 17's a lot in 3 years.
And you have the 7th, you said, is pending next week.
Next week, I would presume we're going to move forth a 7th, but I don't know that.
So you were asking when,
Misty Mountain had their meeting.
okay, so they were interviewed 7/24/19,
So June of 19.
July, yeah.
I'm sorry, July of 19.
July 24th of 2019.
Thank you. Thank you, sir.
You all set, Eric? Good. Any other questions for anyone? Councilors, do you have anything you'd like to add? No? Very good. So let's move on to paper 319. Wh- Who's doing what, Peg?
And this is the most straightforward of them all. And so this is really, as we know about if it's a new construction and they have to go for variance, but if there's an existing building and a new or increased violations of dimensional controls or parking requirements may be allowed by special permit in the special granting authority. Makes those, as you do when you do this, that the violations are not more detrimental to the neighborhood. So no variances are required in something that's pre-existing non-conforming. This just brings the same language into each one of these other areas. residential use and institutional business, industrial property would preferably preserved, fast food service restaurants, drive-throughs, gasoline filling, and service stations. So it just brings that same language into all the areas. So it doesn't matter where you're looking at, it is exactly the same, kind of aligns everything.
Okay, are there any questions for the counselor?
Well, I really appreciated that this came forward, and if you're curious as to why this has come forward as part of the cannabis package, it has to do with the paper that we're not going to discuss today, but 315, because we had some very long discussions trying to dig into when there are regulations that are not the province of the Board of Appeals, right? Because their role is very clearly defined in state law. Who, if anyone, is able to entertain any deviation from the exact text right there, regardless of the context, regardless of the way other things are compensated for. And Building Commissioner Nelson in particular pointed out that we have an understanding and a practice that special permit granting authorities can not grant a variance or but have a finding that is consistent with the standard they have to use, that it's not detrimental to the neighborhood, right? And so then we realized, actually, we need to clean this up in all other parts of the code as well. And so our dutiful city staff, planner, building inspector, legal department, got that same language and put it forward in all of these other sections to clarify. So, I know we characterized that other paper a little earlier as, creating new powers to change certain regulations. I actually understood what we were trying to do is codify what is unspoken current practice to make the whole thing more transparent. It doesn't necessarily alter an authority, but it clarifies where that authority resides, and it does it systematically across the city code. So I just, as somebody who appreciates the value of a well-written piece of public policy, I just think I really appreciate it. I think that kind of consistency avoids the obfuscation. That means you just got to know somebody to know how the process works, or you just have to have been around and see and read between the lines and compare state legislation to local code, and it just lays it all out there and says very clearly, this is where the authority lies. And so I hope that you will embrace that as well. Thank you.
Thank you, Counselor. What's that? Okay, go ahead.
Yeah, I just wanted to thank Council Crowe. That was excellent overview of it. I did work closely with the city solicitor to put forward these what we're calling administrative in nature. They're important updates. It's not changing the way we do anything. It's just codifying what we already do. For all these different uses that have require special permits. So it's not changing where a special permit's required or who grants a special permit. It's just updating the ordinance so that our current protocol, and I'll mention historical protocol, because it's been this way for the 20 years I've been here. It's always been interpreted this way. It just wasn't expressly written that way. So I think that this is very, very important, and I'm glad that we've had the chance to add this into this, as they call it, the package of legislation. I do want to note one thing, though. I will take one exception. Paper 315 does make a substantive change. These are not making any substantive changes. This is adding a sentence to each of these provisions. It's the identical sentence, and it will just give across the board clarity. When a special permit's required, does the special permit granting authority what they're considering, which you do all the time, as the counselor said, and for new construction, when variances are required. So it's very, very straightforward. I didn't repeat all the language, but it's pretty much the identical provision repeated. So it's anytime you need a special permit, where it's allowed by special permit.
Okay, Eric Henry, no? Okay. Any other questions about paper 319 for the counselor? And the counselors don't have anything more to say? No, good. Okay, so if no one else has any other questions, then what we'll do is move on to those that would like to speak in favor of any of these four papers. So we're taking comments anyone might have on papers 316, 17, 18, and 19. Name and address for the record, and please make sure you print your name on the clipboard. Thank you.
My name's on there. My name is Amy Friedman. I reside at 8 Marvin Street in Malden. To start off, I'd like to say that I came tonight having done my research on these items for a public hearing. And we're 2 hours into this meeting before the public has had a chance to speak. I appreciate that it may take you all 2 hours to do your debate and do the work that you want to do to make decisions about this, but the public shouldn't have to sit here and wait for 2 hours to speak. We have other things to do, we have family to get home to, and we want to have our say before you debate these things, with the hope that you will take into consideration what we have to say. So moving forward, with all due respect, maybe that's a process or procedure that could change so that, you know, we're not sitting here trying to get through a marathon and worrying about what's going on at home in order to have our say, in order to speak on these things. I'm speaking in favor of the papers that are in front of this board that would essentially make it easier for social equity establishments to establish cannabis businesses in Malden. I think our cannabis regulations are too restrictive to the extent that they may violate state law. And as a former attorney and someone that's trained in mediation and high conflict mediation, I think it would be much simpler if we were being more inclusive and including social equity companies, including people in discussions about these things earlier on, so we're not running into these problems. Malden's cannabis regulations are extremely restrictive, particularly for social equity companies. State law prohibits unreasonably impractical regulations for cannabis businesses. For example, Malden is one of very few cities in Massachusetts with buffer zones around residences. Malden's regulations have nearly completely prohibited cannabis businesses, as very few properties that fit within the regulations are currently available on the market. Few properties fit within the strictly defined zoning scheme, and further, the Zoning Board of Appeals has stated that they will refuse any requests for variances. The effective result of this is that our city is not only foregoing bonus funding for social equity cannabis establishments and other revenues, we are risking litigation by violating state law. Reasonable variances should be reviewed by the City Council and granted to allow cannabis establishments in Malden, particularly small local social equity establishments. I appreciate your time. Thank you.
Thank you. Is there anyone else that would like to speak in favor? Anyone else to speak in favor?
Good evening. My name is Gary Oshry, and I'm the property owner at 926 Eastern Ave that's currently applying for an application. And I am supportive of these, but I'd like to take a minute to answer some of the great questions that some people asked up here. So just to let you know, I've been in Malden as a business owner since 1994. I've been following the cannabis through the legislative since 2018. I've been at many of the meetings, as you all know. I was approached by numerous companies for my building, saying, wow, there's cannabis in Malden, let's talk to them. And my business partner and I, we didn't know if that's something we wanted to go down to. And I was approached by somebody that was a social equity candidate that went to 150 properties in Malden and said, you have the best building. You're next to the police station, you have plenty of parking. We see something special in this building. And knowing that the city council said there was an option to get variances at the time, we felt that we would be a good candidate in the spirit of the ordinances to move forward. There are only 72 properties in Malden, including CVS's and gas stations, that you can actually open a cannabis up with the current regulations. and I ask anyone to tell me if there's more. We have looked at every property. We have had numerous people fact check us. There's 72, and I'd love to hear if there's any others. The primary use is, I own a company called New England Trade. So for example, I have a 6,000 square foot building. If my candidate only needs 4,000 square foot, I could operate my business on the 3rd floor. But the current regulations are not. So I had 6 tenants that I had basically had to not renew their leases on while this candidate is going through the process of getting approved. I would argue Malden is by far the most restrictive community in the state of all the regulations. I have spent countless hours looking at the different regulations, and for example, Malden is only one of 2 cities that is a residential buffer, which I know we're not talking about that today, but just for an example, where I think we're only 2 cities that have the primary use in the whole state. There's 5 licenses that the city will approve. The Cannabis and Licensing Board, when I tell you they're thorough, I've been through it, they look at everything. We were required to raise $2 million and prove that that's what it would cost to do what we wanted to do. We had to get plans, engineers in, equipment, everything we've done by the book following the procedures of Malden. Someone asked how much money, we spent over $200,000. And every month I'm losing thousands of dollars, and my decision is, do I kick my social equity candidate to the street because there's no other properties, or do I hopefully let the city move forward? We want to open up a vertically integrated business, which is all through, we're one of the people that Michelle brought up that want to open vertically integrated. What that means is we want to have a small micro, real small grow, so it's locally grown in Malden, some local manufacturing, and a small retail footprint to service the community. And my office, my building is right at the corner of 99 and Route 60. Every day, cars, as someone else mentioned, are going to Garden Remedies. It's losing money. To give you an example of how much money Malden's losing, the average dispensary right now, according to the Massachusetts Cannabis, which is public, is doing $7.5 million a year. If we gave 2% of that to Malden, that is, how much is that? That's a lot of money. Sorry, that's $150,000 times 5. I've been at these city council meetings. I hear, we need books for kids. The parks need fixing. We need a traffic light here. We're here. We want to give money. We have a local Malden resident, a local business owner. We're not a multi-service operator. We don't have unlimited cash flow. How do you get $2 million? We have to go to friends, family, business owners, tell them what our vision is. And that's what we've done. The talk of all these other candidates coming in, the last 3 candidates that have come in all need variances the same as we do. One of them was going to take 4,000 square feet off their building so they don't have a problem. Another one has more residential issues than us. And another one is next to a field. The issue is there's no property. So by changing primary use, that would be great. That would potentially help me out, that I could operate my business. I don't need to move somewhere else. But the bigger issue is there are no parcels. And I appreciate everything that you guys have done on the city council and the time you've taken, and the building commissioner and Ron and the planning board. I just wanted to kind of clear up some information. I support you passing these regulations, and I look forward to the next meeting of other additional regulations. So thank you.
Thank you, sir.
Honorable members of the Planning Board, my name is Ryan O'Malley, Ward 4 City Councilor. I'm here tonight because previously I've spoken to you and identified that cannabis is being grown and used in residential neighborhoods in our community. Right now, under current law, you can grow 6 plants per household. So if you have a 3-family, that could be 6 times 3. Previously, when I came before you, I talked about how I had found marijuana growing in public parks. Marijuana is in our neighborhoods. Marijuana is within reach of children and people that we do not want it to be in reach with. And one of the ways that we resolve that is permitting regulated and controlled areas where people can buy this in a reasonable and safe manner. The black market is very healthy in Malden. It has not gone away. Arguably, it has better product than the legal market. That brings violence, that brings crime, that brings guns. We've seen this in our community. It's hitting close to home. We see it in Linden. We see it all over our community. Delivery from other communities is allowed in Malden. So the dispensaries in Melrose that are reaping the benefit of everyone from Malden who is going over the border can get that marijuana delivered to their residential address. Drug deals are happening in our community right now, legal and non-legal. I think it's shameful. We're losing out on valuable revenue. And the reason why we're here tonight is because the ordinance as written does not reflect the legislative intent of the City Council when we initially imposed this, or we initially wrote this. We are not professional zoning officers. We depend on our legal department. We depend on planning staff to fill in the gap of what our policy wants to be. And in certain circumstances, that did not occur exactly the way we wanted it to occur. We talked about how we always expected zoning relief and buffer dimensional controls to be varied and relief be granted by special permit granting authorities. We have some provisions that are wasteful to buildings where you're now leaving whole halves of building completely vacant because of a principal use variance. We have some redundancies that we're looking to clean up, and we have some provisions that violate state regulations and processes. Right now, these overly restrictive zoning ordinances unfairly benefit particularly well-connected corporations, large property owners, including large property owners who sit on the City Council, large property owners that indirectly benefit from the fact that there may be as little as 72 properties in our community that are potentially allowed to have this particular use. That's less than 10%. The councilors who own those properties or whose families own those properties should not be involved in the process. They should not be positioning the changing of the special permit granting authority. They should be recusing themselves. Maybe that's why they're not here today. I'm here to speak in favor of eliminating the principal use variance. It's wasteful. As Councilor Linehan has stated, it negatively impacts tax revenue. It overly burdens minority-owned businesses, as Councilor McDonald mentioned, and it's a waste of space. We don't have a lot of space, and it's no reason why buildings should be left empty. I'll give you an example. 184 Commercial Street, where the Super 88 is located, there are multiple buildings on that parcel, opposite sides of the parcel. But under this principal use restriction, you could not have one of those buildings be a dispensary and the other one the supermarket, because it's on the same parcel. Common sense reform like this is going to make this a safer, more equitable industry in Malden. There's 317.22, the security plan requirement. That's just redundant. I agree that, personally, I'm indifferent if we keep it or don't keep it. It's really, I don't think, any difference. I think it's just cleaning it up. It is an ordinance, it's just in a different section of the ordinance. The building permits and occupancy permits, those violate state law or regulations and the process. It makes no sense to not clean that up. The regulations for uses for special permit, this is related to an inconsistency in terms of how zoning variances and relief by special permit granting authorities is doled out in Malden. It was confusing to all of us, including staff, including the legal department, and I'm glad we were able to get to the bottom of it, and ideally we'll clean it up. But as Councillor Linehan and Councillor Crowe had stated, and Councillor McDonald, this is a package. We cannot be just passing parts of this. So I do ask that you immediately call your next meeting so we can address this as a package, because not one of these is going to pass alone. We need to pass all of them for this to be successful. It needs 8 votes. So I ask that you move expeditiously. I ask that you act fairly. And I do think you should ask hard questions of the councilors that were not here tonight. Thank you.
Thank you, Councilor. Is there anyone else that would like to speak in favor?
I am a city councilor at large. I live at 105 Wyoming Avenue. I'm going to be quick. I just want to say I am in favor of passing this full legislative package. I have watched as the Ordinance Committee has worked so hard. I sat in on every meeting. There were some meetings that were, I'm going to say, over 5 hours long. They did their due diligence. They come here before you with, I can't imagine that there's something in here that they did not think of. So I'm hoping that you'll give that a lot of thought and pass the full package. We are one of the most we're top 5 most restrictive cities, and so I want you to think about that, how it affects our social equity applicants. That we need the revenue, just like others have talked about. We need the revenue badly. So I hate going into Melrose. I hate to go to other places. I have to take my daughter who needs, medical marijuana for pain relief, and she has autoimmune disorders. And I hate giving my money to other cities. I hate it. So the sooner we get things passed and the more social equity applicants and shops we have here in Malden, the better. And I think that's about it. But again, I want to thank you for all the hard work here, and I hope that you pass this all tonight. Thank you.
Thank you, Councilor. Is there anyone else that would like to speak in favor?
Hi, David Senatilica, 32 Perkins Ave, Malden. I'll fill this out when I'm done. I just want to speak in favor. I think there's a lot of common sense legislation that could go a long way in making it easier for legal and lawful cannabis to exist in Malden. I just think that the regulations now can be so restrictive that it's simply so many places where it can't go. Amazon has gutted downtown retail. There's so many empty shops that could be good fits for cannabis, but unfortunately they fall within the residential buffer, so they can't go there. And it's my understanding that under the new state law with cannabis delivery, that retail establishments in other cities can now deliver to Malden residents, so that's another huge revenue stream that we're losing. Quite frankly, I don't actually see a logical reason why the residential buffer actually exists. There's a lot of, like small square businesses that have residences above it, or they might have a resident that's adjacent, but that's ineligible for cannabis. You have areas that might fall within the 150-foot buffer, but they're actually inaccessible. Like they might be on the opposite side of a bike trail, where there's trees and fences, but because they fall property line, now you can't do it. So I just think there's a lot of common sense regulations that can change without a detriment to the community. I think that's what we're all talking about. This is not something that's gonna detrimentally impact the community. It's just something that, it's gonna, black market exists, like Councilor was just saying, people can legally grow at home. So, I mean, what are we talking about? We're really talking about empowering small businesses, empowering small landlords, and just bring money back into the city. And a lot of good uses that money can go to. So I think everyone knows that. So anyway, just hope this passes. Hope some regulations can be a little bit less restrictive and burdensome. Thank you.
Thank you.
Hi, I'm Steve McMorris. I live at 412 Pleasant Street. Some of what I wanted to talk to you about has already been covered, and some of it will come up again with paper 315, and you'll see me here again in support of that. I hope you'll give it a fair shake. I just want to note that in our first round of applications back in 2019, there were 11 different groups who wanted to operate here in Malden. In our third round of applications that just closed, there were 2 candidates who applied, and the city had to repeatedly solicit a third to come back in for their third proposal to the city to try and get passed. Part of that is because Malden has developed, unfortunately, a reputation as being unfriendly to business and hostile to cannabis. And we are rapidly falling behind the times. All of the current applicants who are being moved forward with the CLEC and being considered have already opened in other municipalities who are further ahead than us and less restrictive, because almost every yes community is less restrictive. When you make it impossible for ordinary Maldonians to open here in their own community, who are not multi-state operators, who are not multi-millionaires, who have to raise every cent with hard labor, then you end up with people from other states who do not care about our community, who are here to extract resources out of our community without giving anything back that we don't force them to. And the state has now said there's very little that you can force them to give back. So they just come in, they vacuum out resources and money and revenue, and they take it back to their home states. You end up with giant real estate developers with no experience in cannabis and no interest in the people of Malden, making proposals because they can afford to demolish 3,000 square feet of their building in order to meet dimensional controls about parking and things. You know, and those are the people. A $200 million real estate company. Those are the people bidding against the Maldonians here who have applied, who can only raise a measly $2 million. I mean, you were talking about how can anyone do that? And then you have a candidate that's majority Malden owned who did that, and it's still not good enough. And there's no recourse for them because the Zoning Board of Appeals has abdicated their responsibility to consider variances for cannabis companies, which they made in an official filing January of this year. I believe it was January 24th that they put that on file. So now we have this bidding war for a very limited number of licenses that seems almost designed to shut out small, responsible operators, even including people who are at least our neighbors in Chelsea, who have had to come in 3 different times, who have lost buildings and gotten other locations. There's another social equity company that has had 3 different locations brought before the CLEC here in Malden, struggling to find parcels. I myself have been watching the real estate for 5 years. How many of those 72 parcels have even been on the market? How many of them have said they absolutely will not rent to cannabis companies, which is a majority of them, having contacted them personally. So you end up with only applicants who can afford to leave 70% of their building vacant or demolish an entire corner of their property. Instead of responsible, personally invested local operators who care about cannabis, who care about customer well-being, who care about community safety, who will be available to come into Malden if there are issues and to come before the city council and make sure that they are compliant not just with the letter of the law, but with the spirit of community and thriving that we are trying to build for Malden. Strong, past, proud future. That's what Malden is, right? I would just really urge you to consider the fact that it's been 6 years, and in that time, half the applicants that could even get past the CLEC have failed out of the process, and how none of the current applicants could move forward without a variance or a finding. I was going to speak to paper 315. I understand it's not on the docket for tonight, so I'll just leave it with that. But please do consider that there are really good, ethical, compassionate businesses out there who want to come to Malden and help us build that proud future together. And these changes, I think, which have been extensively vetted by the CLEC, by the mayor's office with the help of Ron Hogan, and by the Ordinance Committee. Please really consider them and consider what would be best for our community and what kind of operators we want to have here, especially in such a sensitive industry as cannabis. Do you want someone in Iowa who doesn't care about you or you're just part of their investment portfolio? Or do you want someone who you can look in the eye and speak to regularly and nip problems in the bud before they're even a big deal? Thank you.
Thank you. Is there anyone else that would like to speak in favor? Anyone else to speak in favor? Michelle, do you have anything to read in favor?
No.
So seeing no one else in favor, declare that part of the hearing closed. Is there anyone that would like to speak in opposition to these papers? Anyone to speak in opposition? Michelle, do you have anything to read in opposition?
No.
Very good. Seeing no one that would like to speak in opposition, declare that part of the hearing closed. Michelle, would you take us through your staff report?
I'm reading from the staff report dated August 16th, 2022. I won't read anything that we've already entered in, but this whole document's entered into the record. You have the full text of the amendments. You have the legislative history as well as the actual paper that was referred by the city clerk. Those are attachments to the staff report. You noted at the beginning the public hearing on all petitions is scheduled to be held concurrently. You held that concurrently. We heard about the state law. Well, we didn't. The state law that authorizes us to enact zoning regulations is Mass General Laws, Chapter 40A. The state law that authorizes the city to adopt ordinances that impose reasonable safeguards on the operation of marijuana establishments is Mass General Laws, Chapter 94G. The city regulates marijuana establishments through the licensing ordinance, which we heard about, and also the zoning ordinance. What's proposed here are proposed amendments to the zoning ordinance. I've given you a list of provisions that are relevant in the current ordinance to these amendments. I won't read these into the record. They're here. They're various sections of the current ordinance. You also have a copy of Title 12.12-190 attached, which is the complete zoning ordinance regarding marijuana Regarding 316, which is the principal use requirement, as we heard, it will eliminate the requirement that a marijuana establishment use must be the principal use of the property. Again, it would allow a marijuana establishment to be located in a building or property where there are other principal uses. We also already noted this does not change the accessory use regulations provision of the ordinance, which states that a marijuana establishment may be accessory only to another marijuana establishment at the same property, and that it is prohibited as an accessory to any other use. I mentioned earlier the concern with this particular proposed amendment in conjunction with another proposed amendment that would allow the special permit granting authority to reduce or eliminate buffer zones, that's paper 315, does have the potential to be interpreted to allow the siting of marijuana establishments as a principal use in a building or at a property with an existing principal use with which that marijuana establishment use is not compatible and in conflict. I've given you the list, as I talked about before, for your consideration, to be identified by ordinance as principal uses of a building or property at which a marijuana establishment may not be cited. I don't know if you want to talk about this now, move forward. You want me to give the rest of the recommendations? So these
Please give the rest of the recommendations.
On all the papers?
Yes.
Okay, so that is that. So security plan requirement, we heard what that proposed amendment, this is paper 317, will do. It will eliminate the itemized elements. Some of the board members did, raise the questions. These are required right now by our zoning ordinance. The licensing regulations do require a security plan to be reviewed and approved by the police chief. We heard about the state regs. I will note that the process to change the city's licensing ordinances differs substantively from the process to amend the city zoning ordinance. It requires only an affirmative vote of a simple majority of the council, so 6 of 11. It does not require a public hearing or review by this planning board. So I want to just give a brief note about the history. I was around when the original amendments were proposed to ordain. They were considered. There was an ad hoc committee that was formed by the city council. It was that ad hoc committee that came up with the itemized list of these requirements. They presented it to the council, and it was the council that unanimously incorporated those in. So the council at the time did think it was important to keep those in, even though we knew it was included in state law. The concern was, as the chairman expressed, if the state law changes, our ordinance may not contain the same regulations. So if we defer simply to the state regs and the state regs change, it's no longer in our ordinance. The licensing regs we heard about, again, licensing regs can change. It's a different process. So there was a reason these particular requirements were put into the zoning ordinance. Building, and I just wanted to give you that background. They didn't, come up, they were particularly itemized specifically and put in for a reason. It's certainly up to the council to take them out at this point. Building and occupancy permits we heard about. This is to clarify and correct procedural issues. As the building commissioner mentioned, when we passed the original ordinance, we weren't sure who the licensing board would be. We weren't sure what the process exactly would be. So this is going to clean it up to reflect the current process. In terms of the use regulations for various uses allowed by special permit, again, they are administrative in nature, and they are to clarify and update the language. They codify the current protocol and administration, and as I mentioned before, the historical administration as well. So they will render the language of the ordinance consistent with the current interpretation. There is a memo referenced here from the city solicitor and myself to the city council dated June 1st, where it does make those recommendations. Again, I mentioned they don't change the special permit granting authority, the fact that a special permit is required, or the standards and criteria to grant a special permit. They're adding in additional language to clarify what is already being done. In terms of application exemptions, all these amendments would apply to new construction, new occupancy of existing buildings unless exempt by state law, our local ordinance, the express language of the amendment, or the subject of a building permit, a special permit issued before the first publication and notice of the public hearing, which was July 29th, 2022. So I've listed here for you the following projects that are exempt from these amendments because they do have a building permit and/or special permit issued before the date of first publication, a hearing notice. I'll just list the addresses: 323 Commercial Street, 7 Linehurst Road, and 36 Charles Street. Per state statute, applications for permits that are in the processing stage when publication occurs are not protected. However, historically, the city extends the exemption and protects any pending petitioner's good faith reliance on current regulations, and typically adds language that says proposed amendments do not apply to applications filed prior to the first date of publication of notice. There are no complete applications in the processing stage. I'll note the effective date of the council's vote. The effective date of the amendment is the council's vote to ordain the amendment. In terms of your review, your standard of review and recommendation for zoning changes should be directed by substantive planning objectives, community need, and general welfare. Regarding paper 317-2022, the proposed amendments are largely administrative in nature. Regarding 318 and 319, they are administrative in nature and make recommended important updates, again, to render the ordinance consistent with current protocol. Regarding 316 of 2022, the proposed amendment is not supported by the actual permitting and licensing processes that have occurred in the city since the current ordinance was ordained in 2018. I've mentioned these statistics before, these facts. 6 marijuana establishments were approved by the Cannabis Licensing Enforcement Commission to proceed through the zoning process. A 7th one is pending. We heard from the chair of that commission, the building commissioner, that they've reviewed 17 applications since 2018, or since the ordinance was ordained. 3, as I mentioned, already have the special permit. 2 have been issued a building permit. I mentioned before, one of the special permit grantees is a woman-owned business. 1 petition approved to proceed to zoning is considered social equity. The 7th application pending approval, 1 is social equity, 1 is economic empowerment. I already mentioned the paper that takes into account that the city has already designated that one of the licenses will be for social equity or economic empowerment applicant or 51% Malden owner. The maximum number of licenses we already talked about. This is again only for marijuana retailers. It's 5. That's 20% of the off-premises all alcoholic beverages licenses or package store licenses, and that is per city ordinance. Talked about the equity programs, the new state laws. I've given you a brief recap. There also were mentioned in the presentation to the City Council, which some of you may have seen on April 26, 2022 from Ronald Hogan. I can provide a copy of that presentation if anybody's interested. He discussed the potential changes to the law, which appear to be the same changes that were just signed. So we've been updated on those changes. I will note Malden is densely populated, it's densely developed, you all know that. Most uses are located throughout the city in all zoning districts. The zoning districts went into effect in 1977, so many, many uses and many properties and buildings predate that 1977. So they become pre-existing non-conforming, but that's how you get residential uses in highway business zones, you get other non-conforming uses in industrial zones, etc. As I noted previously, that I'm mentioning that because the concern regarding paper 316, which is the proposal to remove the principal use requirement, again, in conjunction with this other paper that we will hear at the next hearing, whereby the buffer zones can be reduced or eliminated, has a potential to create conflicts. We talked about this isn't changing the zones where marijuana establishments can go, but if in fact principal use requirements change, it will have an effect on that. It should be addressed by the ordinance. That's my recommendation. So the recommendation is made prior to the public hearing is that the planning board recommend to the city council regarding paper 316, which are the principal use requirements, amendments to section 12.12190E, that you recommend disapproval of the amendment. However, that you also recommend, if the city council approves any amendment, that the following provision be added. A marijuana establishment shall not be a principal use of and or located in the same building or on the same property, which, as of the date of filing of the petition for special permit for the marijuana establishment, is lawfully used for any of the following. I've listed several different, I won't read them unless you want me to read them into the record, and then I recommended you review them and consider them. for inclusion. Do you want me to read them into the record?
No.
Okay. Do you want me to move on to the next recommendations? So the recommendation regarding paper 317, which is amendments to section 12.12190H.2 regarding security plan requirements, is that you recommend approval as proposed. In terms of paper 318, approval of the amendments to section 12.19H9 regarding building and occupancy permits, that you recommend approval of the amendments as proposed. And then finally, regarding amendments proposed in papers 319-2022, which are of sections 12.12010A1 and A2, 12.12010B1 and B2, 12.010C1 and C2, 12.060A and B, 12.070A and B, 12.150A and B, and 12.12160A and B, that you recommend approval of all the amendments proposed.
Very good. Thank you, Michelle.
For your reference, I will just also note, you will be making a recommendation to the full city council. The planning board is required by statute to have the opportunity to make that recommendation. If 21 days elapse from the date the hearing closes, so it closed tonight, the council can proceed without your recommendation. I would strongly recommend that you make the recommendation tonight if you intend to make one. We probably will not be convening again within 21 days. So you will make the recommendation, it will be submitted to the full city council, they will accept it in. Then they have the option, they can refer it to the ordinance committee for further discussion, or they can take it up upon receipt and take action on the amendments. They are the ones that are authorized to vote, to enroll and ordain ordinances. The mayor does have veto power. And so again, this is an advisory recommendation.
Okay, thank you. So, let's move back to paper number CCP 316/2022. Does anyone have any questions for Michelle, or is there a motion? We're kind of into our portion of it, but go ahead if you'd like to.
I just wanted to ask, Michelle, is there a reason if the concern is about the interaction with 315, is there a reason that you didn't recommend that we just not allow there to be uses on a site for which there are any buffer zones to apply?
The concern has to do with 315, and it also has to do with other uses that may be incompatible in the same building or at the same property. So the buffer zone question is a different question. Buffer zone looks at the location of an entire parcel in relation to other parcels. This amendment is looking at what's going on in the same building or on the same property. So I believe there's two different inquiries. One is to capture everything that's potentially in a buffer zone that may no longer be in a buffer zone, but also to look at what other types of principal uses, which was the intent to putting this regulation in the first place. There was a question in a concern, and it was decided by the council that this was appropriate, that we restrict marijuana establishments to be the principal use of buildings and properties. Again, this goes to the dense development of the city in general.
Thank you. Thank you for your allowance, Mr. Chair.
Thank you. Okay, so, vacant. Okay, we're good. Okay, is there a motion? Does anyone want to make a motion from the planning board about a recommendation to the city council?
And I've given you the table of use regulations as well, so you can look through the same list that I look through to see if there's anything that looks like it's missing or out of order. Again, I went through as an exercise and identified ones that I wanted to call to your attention for consideration.
Thank you. Eric McCush.
Thank you, Mr. Chair. Just in consideration, a lot of the discussion was about how this is preventing social equity applicants, minorities, and Malden businesses from participating in marijuana businesses when in fact, they are in the pipeline. And it doesn't seem like the principal use regulation is prohibiting them specifically. I'd like to make a motion to make the recommendation to deny the special permit for 16, or the change for 16, and maintain the principal use requirement for the properties. The only other places I know of are in Gloucester and Melrose, and both those facilities are principal use facilities. I don't see a reason to change that, but also add in the caveat, if they do make the restraints, use the restrictions that you recommended.
Okay, so essentially you're basically making a motion for disapproval of the amendment based on the recommendation of staff?
Correct.
With that added piece that should the council not adhere to our recommendation, that they include the items that Michelle listed?
Correct.
So this additional provision with
Yes.
these, okay, right.
So are you all set, Michelle? with
Right,
that?
so the motion is to disapprove the amendment as proposed, but also to include the recommendation, if the council approves the amendment, that the following provision be added.
Right.
Okay.
And Eric Henry.
I can second that motion, Chair.
Eric Henry seconds Eric's motion. Eric McCush's motion.
So a yes vote is to recommend disapproval with the additional recommended provision in the event it moves forward.
And give me a second to get ahead of you here. Okay, go ahead.
Ken Antonucci?
Yes.
Diane Chuha?
Yes.
Tawadej Gebrselassie?
Yes.
Risa Gray?
No.
Eric Henry?
Yes.
Eric McCush?
Yes.
Henry Susi? No. Ronnie Raj Verma?
No.
Chuck Iovan?
Yes.
Okay, so that's 6-3, so that motion carried. You needed a majority vote to carry that. So we will make that recommendation in writing.
Okay. The next item is paper 317/2022. Is there a motion? Henry Susi. Oh, wait a second here. I think I'm backed up a little bit. Henry, were you looking to make a motion? I see your name here. I'm just kidding. Ken
I can make the
Antonucci.
motion.
Ken Antonucci.
Mr. Chairman, I'd like to make a motion to approve the amendments proposed in City Council Paper 317.
Okay, would you like to, and Henry Susi? And Henry Susi seconds.
So a yes vote is to recommend approval of the amendments as proposed. Ken Antonucci?
Yes.
Diane Chuha?
Yes.
Tawadej Gebrselassie?
Yes.
Risa Gray?
Yes.
Eric Henry?
Yes.
Eric McCush?
Yes.
Henry Susi? Yes. Ronnie Raj Verma?
Yes.
Chuck Iovan?
Yes.
So that passes 9-0. The recommendation will be made in writing.
So for paper 318, is there a motion? This is the one associated with, let me get the right wording. This is another administrative one, building and occupancy permits, straightening out the process so there are no conflicts. Ken Antonucci.
Mr. Chairman, I'd like to make a motion to approve the amendments as proposed in City Council Paper 318.
Very good. And a second, Eric McCush.
I'll second that motion.
Very good.
So a yes vote is to recommend approval of the amendments as proposed. Ken Antonucci?
Yes.
Diane Chuha?
Yes.
Tawadej Geber Selassie?
Yes.
Risa Gray?
Yes.
Eric Henry?
Hold on a second.
Yes.
I'm caught up here. Okay, so Eric Henry, we got.
Eric McCush?
Yes.
Henry Susi?
Yes.
Ronnie Raj Verma?
Yes.
Charles Iovine?
Yes.
9-0, motion carries. We'll make the recommendation in writing.
Okay, so the last paper, 319. This is the one associated with the use regulations for various uses allowed by special permit. Is there a motion for this? Ken Antonucci.
Mr. Chairman, I'd like to make a motion to approve the amendments proposed in City Council Paper 319.
Thank you. Is there a second? Henry Susi.
I'll second that motion.
Henry Susi seconds Ken's motion to approve recommendation staff.
Recommend approval.
Approval, yes.
So a yes vote is to recommend approval. Ken Antonucci?
Yes.
Diane Chuha?
Yes.
Tawadej Geber Selassie?
Yes.
Risa Gray?
Yes.
Eric Henry?
Yes.
Eric McCush?
Yes.
Henry Susi?
Yes.
Ronnie Raj Verma?
Yes.
Charles Iovine?
Yes.
Motion carries. We'll make the recommendation in writing.
Very good. Well, thank you. I pass it over to Councilor Crowe if she wants to make any comments and adjourn her team.
No, I just thank you for your time and attention to these important matters, and do we hear a motion to adjourn the Ordinance Committee? By Councilor Linehan, seconded by Councilor McDonald. All those in favor? Aye. Thank you very much.
Thank you all very
Enjoy
much
your
for
night.
coming up and your time. Okay. So, Michelle, because we get stuff intermingled here, should we keep our packages and papers?
You can if you have notes on them. Just remember to please bring them back. If you leave them on the cart, make sure your name is on them, so we will put them, in your proper folder, and you will get them back the next meeting. I will bring extra copies of stuff, so if you take them home and you do forget them, but we won't obviously have your notes. So the two papers, paper 286 and also the paper 315, which you did not receive any information on, but this does contain information about 286.
Okay.
So it's up to you whether you want to bring it.
Next item on the list is Community Preservation Committee status report. Let me get Mr. Henry. There we go.
Yes, thank you, Mr. Chair. Community preservation is, I imagine, about a third of the way through its, quarter or a third of the way through its annual process of approval and stuff. We just had elections. We have co-chairs now for the first time on CPC, and I'm one of them.
Congratulations.
Yeah, okay, thank you. And, yeah, so we have we just completed one project, the wall, you guys may have noticed at Highland Ave and Route 60 there. Refurbished that wall there, it turned out pretty good. But any questions, I'm more than willing to try to answer them or move
Anyone
along.
have any questions for Eric?
Yes, sir.
First of all, congratulations.
Yes, sir.
And so who's the other co-chair? Is it Lisa?
Yes, yes. That's how it turned out. So Lisa and I are co-chairs, so gives me an opportunity to learn a little bit more.
Nice. Congratulations.
Some people are born to greatness, others have it thrust upon them.
And then I can vote for someone. Elections are coming again.
Well, thank you very much, and
You're
glad
welcome.
you're enjoying your time on it. The next meeting is September 14th. Should be back to our second Wednesday again. We'll let people know we're likely going to have a joint hearing, and it looks like we might have Highland Ave on also. 204 Highland
Yes, we did table 204 Highland Ave, and they weren't on this meeting, so they are scheduled to be on. I'd already notified the petitioner that before this all happened, so. I believe we'll do that. We'll do the joint hearing and we'll do the one petition, the special permit petition.
Okay, thank you. Any questions? No? Is there a motion to adjourn? Diane made the motion to adjourn, seconded by Tawadej Gabriselassie. All those in favor say aye. Opposed? Motion carries. Enjoy the rest of the summer, everyone. And Tawadej.